Even small cases of home bias claim and number of claims disputed, deleted filed, not filed, properly filed. Sharpie can revise the claim, IRP can or liquidator can admit the claims which are not admitted. Lot of issues keep coming. And you have an in-depth study. And study should be beyond the normal form filing and what is to be done. That was the purpose of this meeting. It should be an interactive meeting, a full-fledged question answer meeting, and the brief of the case laws which has come out in last 4 5 years. With this, we have today a very learned speaker, Mr. Vishnu Sriram, partner in Hetan and Company. They are into restructuring activity, and over a period of last 7 to 8 years, he has advised number of large cases. He has advised Sharendra Ajmera, SBI, Reliance Industries, Diwan Housing, Bharat Forge as a resolution applicant. He is advised in our case also, Videocon case for almost 5 years, Lloyds Bank, and number of other cases he is advised. And he presented lot of papers also. So with these few words, I introduce. Another side is we always try to have one from the law firm and one from the RP fraternity, so that we get best of the both worlds. We have Rahul Agarwal, sir. He is with Director Debt and Special Situation Fund in ENY. He has a deep experience of running CRP, assisting client with operational performance and improving across transactional life cycle. He is working with startup and traditional business with sector like e-pharma, healthcare, retail and manufacturing. Previously, he was working with IBC Limited as a manager finance. He has obtained experience in strategic design, transition, business planning, and project management. Rahul is a chartered accountant, company secretary, holder of bachelor degree in commerce from Saint Xavier College, Kolkata. I think cases are one of the large cases he's been handling is Think and Learn Private Limited, that is Byju's case. It is not only famous in India, it is world over famous now. And Reliance Broadcast, 7 is hospital, is also a large case. Reliance Big Private Limited, Reliance Big Private Limited, Innovative Industries, which was the first case. Future Agro, Bharti Defense and Infrastructure. So we have both sides. One is on the RP side and one is on the technical side. So now I request you both of you to start with the whatever presentation and main focus is on questions. Yes, she is our institution secretary, General South. Yeah, आ रहा है, आ रहा है.
So we can start.
Yeah.
To close that sidebar, that's coming from you only, Ashwin.
No, I have done it first, but they have to do it from
So while it, good afternoon, everyone, and I think we are in.
Thank you so much.
सर आपका भी एक फोटो ले लो. With the same calendar you have to again. मेमोरी में नहीं है ना. I think we keep doing again and again.
The member presents are all RP, mostly practicing, mostly each of them have done 5 to 7 or more than 10
Yeah.
things. Then they are now they are practicing as an
I think it's a good forum to interact to know.
Good forum to interact, yes.
I think we are in a fairly learned company in terms of how IBC process works. So I mean, while we sort of covered what is claim verification, but I think we'll have a more nuanced discussion. All of you are, all of you are very experienced professionals, and since the IBC, I think, is now, I mean, touching about 8-9 years of age, and we've seen tremendous evolution of the law since it started. Even on the claims part, I think it has been evolving more so that I think the key takeaway that we see as legal practitioners is that claim verification is not a clerical exercise. Maybe that was initially the feeling in IBC that you have to just collate some numbers based on documents, but more and more that because from claim verification, so many rights flow. And I think we've seen so many cases where claim verification actually decides who the successful bidder is. Right? So it goes to that extent. So we had, I mean, broadly, we've divided it into the treatment of claims in CIRP and liquidation because that's a key difference between how claims are treated. So we'll quickly run through what the process is and then we can go into some issues. I mean, claim verification, like I said, is, I think, the bedrock of for the basic key body in the IBC being Committee of Creditors. IBC under the Indian law, it's unique in that it's a creditor in control model, what we call as a creditor in control model, which is different from, say, the Chapter 11 proceedings in America, where debtor is in possession of the corporate debtor. This committee of creditors is formed by the resolution professional. It is not formed by a court adjudication. That resolution professional, therefore, holds the keys to decide which is the primary body which takes key decisions and has veto rights in terms of decision making for the entire 180, 270, 330, whatever number of days the process. And earlier we had a longer period of time for verifying and forming the committee of creditors. There was more than 30 days earlier to start with. That has also been brought down because now you have to do it in 14 days from submission. So you have right from the get-go. I think in fact, the way we see it now, the key role of IRP is actually claim verification. If you are able to do that to the best of your abilities, I think in those 30 days, that's the main task. I mean, because taking control of assets, yes, in some cases, you have difficult situations where corporate debtor and management are difficult and there might be threat of assets going away. But most cases, they are not difficult. In most cases today, because IBC has set in and even the management knows when NCLT order comes, they don't have power. So that resistance has died down. So claim verification is an important aspect right from the get-go, what IRPs do. And there is a procedure, there's a public announcement. Public announcement now recently pursuant to some court decisions, in addition to where registered offices, wherever GST registration is there also resolution professionals are advised that you do public announcement. It's not mandatory, but it's a practice because ultimately the idea is wherever you have principal place of business, you make a public announcement because there are the places where claimants are likely to be. Because ultimately your job, as we will see, is not passive, but it's active. You have to give the truest reflection of claims possible. And yes, of course, you do need a claim form. But if you know that there is a claimant, it's also your responsibility to try and get that claim from that person and not remain passive that I didn't get a claim form, so I'm not going to do anything about it. So with that, I think we can move into what the exercise of verification is primarily.
One of the case actually where I got to know that the admission is there, and within few hours there was a settlement agreement come on my table. Within few hours, same day almost. Evening 5 p.m. I came to know the case is admitted. Next day morning 11 a.m. I came to know that matter is settled. And everybody requesting me not to issue the Form A. I said, my role is to issue Form A. They said, don't issue the Form A. We have already settled. We have given you the settlement. I said, I will issue Form A. Unless the court withdraws it, I have to issue the Form A. without any information, I issued the form. After 3 days, I came to know that they are operations in various states. So subsequently, additional form was also issued.
Yeah.
And this was the stand taken, but it was a very entire company people coming and saying don't issue anything because their goodwill is at stake. And I had no choice but to issue the form because form is to be issued within 3 days.
Sir, I also faced similar situation in my initial days. At that time, I had a fight actually in the courtroom because the very next day they appeared in the courtroom saying that we are settling the matter and RP should not initiate the things. As a RP, I attended the matter myself personally, and at the hearing, I told the banks that if you yourself directs me, I will stop the proceedings. That Judge said no, unless the application comes to me, I cannot direct you, but you have to take care about them. He directed both the applicant and the CD, that is CD's team, and the applicant that you handle the RP. They both were after. I have a series of mails, one saying file the paper ad, another saying don't file the paper ad. Even though settlement is documentation is done, but I have not received funds. 3 days were very critical because every day the hearing used to come on board. One day one party, other day other party. Fourth day when the hearing came, the judge is asking me, yes, RP, what you did? Have you did the publication of paper ad? I said, sir, from my end, I have done my job. He said, which paper it is published? I said, I have sent to publisher. But publisher has not published. It is beyond my control. And then he said, produce the mails. So we produced the mails. And then after he gave the order, and then I asked them to stop the press release because 12 is done. Sometimes I feel as a RP, this is a resolution process. If some resolution is happening and it is vital, where there is huge number of public employees at stake, probably a call can be taken to find out a way, but not at the cost of ruling out of the law. What you did is also correct. What I did was also correct. I have sent it to the newspaper publication agent and called it publish nahi karna. Lekin mail pe sirf itna hi tha mera. We got it resolved. So James, the key collect or issue Sriramji we face is when this 12A thing comes into and when there is other claims who have already floated in. At that time, that is the time where we have a challenge because the applicant has settled. Okay, but about the claims we have already received by that time. So 12A, when the application is made, we mention we have already received, let the bench decide. But that is one area, gray area, which I feel needs to be answered by law itself in days to come, where they say that 12A cannot be proceeded either when the claims, all claims are settled which have been received or something. Because today, series of cases, matter settled within 5 days, another matter, applicants matter getting admitted. In one matter, 3 times it was admitted, 3 times settled, 4 time it went till liquidation. So this is waste of time of judiciary and everyone. All the 3 matters where initially RP was appointed, he did his efforts, and I don't think he would have got any remuneration. In 3 days, if it is settled, no one is paying the remuneration. So it's a waste of efforts, time, and money.
There are both sides to this because come to that since we're discussing this, I'll just say there are actually 3 orders. Legally speaking, there are 3 separate orders that are passed when a petition is admitted. There is an order under section 13, there is an order under section 14, and there is an order under section 7. There are 3 separate orders, although always found to be more or less in the same order sheet. One is an order admitting CIRP. Another is an order ordering moratorium is commencing. And a third is an order directing the IRP to issue a public announcement. So you have been ordered to do public announcement. And there is a reason also, because in some cases, the consequences can be serious. In very early days of IBC, one of the first resolution plans actually to be approved in Bombay called Murli Industries, the early case, when a larger plan was approved. The Dalmia Industries had taken the plan. I was advising the resolution. There, this concept of issuing public advertisement in different places was not there. This company went into CIRP in March 2017. So just 3-4 months after IBC had come. They issued, registered office was in Bombay. They issued public announcement. But the factory was outside Nagpur. And in Nagpur, they didn't issue. Now, registered office had shifted from Nagpur to Bombay. So they issued public announcement in current registered office. But there was a company petition under winding up filed where the earlier registered office is, which was Nagpur bench of Bombay High Court, where there was a just 5 days before NCLT order, provisional liquidator was appointed by Nagpur bench of Bombay High Court. And nobody knew about this for 1 year. When the resolution plan of Dalmia Cements was approved, then this order came out. Because promoter was sort of keeping that order and not disclosing. Then he said entire insolvency process is bad because there is already provisional liquidator. And that could have been avoided in this public because Nagpur bench asked us, but did you announce anywhere that insolvency is commenced? How will we know that insolvency is commenced? We are going on hearing this matter. We are sitting in Nagpur. You should know that the factory is here, so you should make public announcement there. So the whole thing turned on this because even then the text of the law said registered office and wherever primary place of business. Now, cement factory had been closed and shut for almost 7-8 years. So RP thought not necessary to publish. It's a defunct company. There are no employees. Everything is closed. Electricity line is also not functional. So therefore, this is one is of course what you're saying that it's waste of energy, effort. But unless you announce, there's also consequence that somebody can say we didn't have constructive notice because publication is constructive notice in law. The moment you publish, then you can take a positive stand that you knew there is moratorium. You knew insolvency is commenced. So thereafter, whatever you do, you are bound by consequences of insolvency. So that advantage is there by publication. So generally what we see, unless it's a case where for strategic reasons you don't want to announce, like say some orders will go away. If you have government contracts, the moment you do public announcement, something may happen to the value of assets. Otherwise, generally we say that you do the announcement. Announcement karne se there is nothing negative that happens in most cases. After that, they can always go to court and settle and do things.
But in those cases, जहाँ पे value कम होने वाली, where the very erosion is there, you RP have a power of doing.
You don't have a power. That's what you don't have a
See,
power.
what I'm going to do is I'll just give 2 examples to this. And as Vishnu was also referring, it's always good to over communicate when there is a need, in order to, ensure that all the stakeholders are aware of it. And people also put their claims timely. That reduces the complexity the RP may face going forward. So I'll just give example of this this think and learn which we are doing. We may not, so we would have done public announcement as per the law at the registered office and the principal place of business, which is Bangalore. But there are 220 centers across the country, right? What we did that, okay, may not be a public announcement through a newspaper because that could have been very costly for us. For all the centers, we have pasted a notice that this is the copy of public announcement and this company is under insolvency. So that whoever is going there, teachers or any stakeholders who are going there, they are aware that, okay, now this is the process and they have to file a claim. So good to communicate. The other point, some other insolvency which I was managing, the media one. It was a media company, and media as a business is highly sensitive. If you say that this particular company is under insolvency, all the advertising agency may not do business with you because they may feel that they will not be getting paid. All the RJs, all the creative people would leave you because who would want to work with an insolvent company at that point in time. So we had to be sensitive. We had given public announcements in a very less known newspaper, so that from a compliance point of view, we have done our work. And and there's not much of noise around insolvency for that particular company. And also while doing that, we have done multiple sessions with key stakeholders to ensure that okay, this is the insolvency process. While the announcement has gone, you may be my customer, my vendor, but this company is in a positive thing, and there are multiple situations which has happened in the past when insolvent companies have come back and turned around and done well, which is positive also in this case. So those kind of communications needs to be made. So RP need to ensure that they're communicating well basis the business and the sensitivity of the business around.
See, in one of my case, the case was admitted on 14th November 2022. where one RP was appointed. And there was a stay. This application was filed by SBI. And there was a stay in that appointment. Subsequently, I was selected by Punjab National Bank. On 22nd of December, matter came up for hearing again, where our counsel stated that this case has been already admitted. But the judge told that today the matter is scheduled for pronouncement of the order, not for hearing. And he admitted me as the second IRP. And this happened on 22nd of November. And from next day onwards, Christmas vacation was there. So he told me to give the public announcement. So for same case, 2 public announcement happened. And there was utter chaos. I used to receive 100 calls. Everyone was surprised.
Was it different bench or the same bench?
No. NCLT Mumbai,
Okay.
but 2 separate courtrooms.
So this is actually, it is actually now, I don't recollect when this decision is, but there is an NCLAT decision which clarifies this, that they are not supposed to do this. For instance, if you take the case of City Networks, the Z Group company, there also both IndusInd Bank as well as IDBI had both filed Section 7 petition. IndusInd's Section 7 petition got admitted first, and IDBI Section 7 petition also in the meanwhile was reserved for judgment. IndusInd's petition got admitted, they went to NCLAT, the management, they got a stay from NCLAT. And then IDBI's petition came up, and they were in fact asking the same question from the lawyers, that should we admit what are these? But
Bench was asking.
Because bench said that on what basis do we say that? So initially they adjourned the matter. They said, okay, 2 weeks later, let us see what NCLAT does. But obviously the process goes on much longer in NCLAT. So eventually they said that we are adjourning the matter sine die. We are not passing any order. We are taking on record that NCLAT has stayed. If NCLAT appeal is allowed and that CIRP order is set aside, then you mention it, we will decide and pass order in this.
But in this case, NCLAT order came IRP to continue. Which IRP to continue, they have not specified in the order.
No, actually, you have to be a bit proactive, I feel, in these situations, because this.
That's why I gave the public announcement, second time.
No, I mean, in terms of going to court, and I mean, you should at least place your position. I hope that this issue is still not happening, because now I think the process is at least clarified. Courts are not supposed to pass a second order.
So sometimes still it is happening, but like what is happening, the promoter's mischief in this case, the operational creditors application, which is kept on hold. And when it financial creditors application reaches at the final stage, the operational creditors gets admitted a day before the financial creditors pronouncement is to be done. You will find this very common on a regular basis. But yes, if the party informs to the bench, but when the FC hearing now, of late I have not seen they are accepting it. They say that already matter is admitted, so this becomes infractious.
Right.
But this is a very common one-day game happening.
Yeah, as regards issue raised by Praveenji, he mentioned that the moment the order was passed, both the parties were there before him, and they said that we are entering into a settlement.
Entered into settlement and copies given.
So obviously, so I say that once it is done, there is provision in law for withdrawal of the CD from CIRP. So it was a fit case for not publishing the public announcement and actually filing. So you have 3 days to publish them, right? So on the second day you could have filed. That is what I.
Only form FA, if he receives a FA form, then he can stop. If he receives any other document, he cannot stop. He is bound to do. Form FA मिला तो उसको stop करना.
Admission order is communicated, second day settlement happen. Our period starts from the day first.
नहीं सर, आपको लेकिन 3 दिन के अंदर आपका पेपर ऐड से पहले FA मिल गया ना, तो आपको स्टॉप करना है. तो फिर आपको स्टॉप करना है. The day you receive the FA, after that you cannot
No,
publish.
actually, Sanil bhai, there is a law. See, FA, you are not deciding authority. श्री शेड्यूल में भी बोला कि यू आर जस्ट वेरीफाइंग अथॉरिटी, यू आर नॉट एडजुडिंग अथॉरिटी। वो फॉर्म एफए विड्रॉ अलाउ करना है नहीं करना, दैट ऑलरेडी डिसाइडेड बाय एडजुडिंग अथॉरिटी। You can't take call.
बेंच में
हाँ, bench में जाओ, you can, if you want, at the most IRP can write a note.
Yes, if you are filing FA, there is no need.
Form filing FA, I am of a strong view that if I have filed form FA, then I cannot publish paper.
You should possibly, in both situations, let us take the first case that you have not got a form, but you have got some confirmation that there is.
Then go ahead.
Then in that case, ideally what I would do is I would ask the applicant and the respondent in the matter which has just been admitted to immediately mention the matter before the NCLT, because it is post admission, I agree.
Yes.
But it is post admission, but pre-public announcement. And they should say that we have entered into a settlement, give us 2 days to submit the form FA. Until then, RP will not publish. Bench is unlikely to pass an order, but at least you will have put it in their knowledge.
Yes.
Bench will say you bring the form, today I am not passing any order, because bench also, they can't pass an order without an application. They are not a high court at the end of the day. They don't have plenary powers like we say in law. They are also guided by procedure. So bench is likely to say, okay, you submit it, I am not passing any order. They will leave it to your discretion. So there is some degree of, I wouldn't say risk, but it's discretion that RP has to use. If you know that the parties will give you the form in 1 or 2 days, then you can file it. And in that application for form FA, you can always make a statement that in view of that, we are not making public announcement. That I don't see is this thing. And when the court comes, you have to basically place it on record why you have taken that decision. Because tomorrow you don't want to get into some issue. But like Rahul was saying, I mean, over communication is trying to take a very conservative approach. If you don't want any trouble from anybody, I will go by the book. But having said that, in 9 out of 10 cases, if RP simply goes by the book, there will be no resolution. Because India is a place where you have to, there is always a gap between what happens practically and what happens in the law. So you have to take a practical approach. And as lawyers also, that is what I mean. We always look at it that way because we are commercial lawyers. Like, so we want to see it that way. Of course, it's very important. Like, as if an RP is my client, it's my duty to always protect the RP's interest, to counsel in a way that tomorrow it should not be that RP has disciplinary proceedings.
Yeah.
So of course I need to take care of that, but there are ways to do it. I mean, without having to expose yourself, but also try to see practicality in things.
So what is the second scenario when you receive the form FA?
When you receive it, you readily file it and you tell the court that I've already filed the settlement. So, if you're filing an affidavit with it in an application, you put it on record that I am not issuing it because I have received a settlement.
See, what happens, normally we get this, we came to know because the NCLT also appoints. Wherever we have submitted this form, we come to know little bit, but wherever NCLT is appointed, we come to know by evening 7 PM also. And we tell them that you don't send it today, you send tomorrow morning to us. But the party, the lawyer clerk says, no, we will send you today only, and they send by email same day night. We get sometimes, among this public admission course order by evening 7:30 after office hours. And next day we have to prepare the announcement and give it to paper, so it will appear on the third day.
Yeah.
And then this IBC, there are no Saturday, Sundays or no holidays. So this is a typical situation where we don't have much time. Wherever the people say, you go to NCLT. How I will go to NCLT? That is my difficulty. Practical difficulty is that when I will go to NCLT and who will pay that cost? And in Bombay also we are say 20-25 kilometers. We'll have to appoint some lawyer. And tomorrow party will say, we will not pay you cost. They will stop the advertisement. But when it comes to the cost, there nobody is ready to pay.
फॉर्म एफए में आपको गारंटी या सीआरपी कॉस्ट का कमिटमेंट आता ही है.
नहीं ऐसे आया नहीं के बाद बाकी तो जो बोलते हैं ना, you go to NCLT going NCLT is your set tender.
No, I mean, but there are risks in both of them. The completely risk-free approach is to make the publication. You are RP, how do you care what happens, right? You are the RP. Your job is to publish. How do you care if he settles?
Sir,
Doesn't
but when
settle?
settlement is happening at that point of time,
Sir,
publishing the form FA, at the end of the day, reputation is definitely.
No, I understand, but I
If you are very sure, if you are very sure settlement is happening, at that point of time, you can take a view that.
No, therefore I said discretion. But I'll give you an example where things can go wrong because of this. There is again this case of city networks, right? Where the judgment of the NCLAT is awaited. But an interesting thing happened before we move to the next issue. On what is the date on which claims are invited? What happened in that case? NCLT admitted they went to NCLAT and got a stay. Public announcement was made. This is not on public announcement. That was made. But before claims really came in or RP could do anything, they got a stay. In about, I think, 10, 12 days, the promoters got a stay. Now, in those 10 days, RP had actually not even taken charge of the company because they are also, they were not willing to let him take control. They said we have filed an appeal. Let the appeal hearing come. If on the first day NCLAT says no stay, then you come and take charge. Till then, we are not giving you charge because it's a media company, it's a TV supply company and everything. They didn't want to disrupt company. They got a stay. So RP actually never even stepped into the company. Okay. So now question became, is the RP appointed order? Because the order said, the NCLAT's order says operation of the impugned order is stayed. Now what does that mean? NCLAT, RP did not file any clarification with NCLAT, and not that NCLAT grants it. NCLAT will say, I have passed the order, you do what you want, because we have seen that also in many cases. RP decided that whole order is stayed, therefore company is practically not in CIR. Anyway, management was in control, management continued to be in control. They had a TRA arrangement, lenders, etc. Now, what has happened? This stay continued for about 6 months. In those 6 months, the lenders realized that the promoters are siphoning off assets out of the company. They are diverting receivables because it's a business which had no real asset. All the set-top box and all are the assets, useless assets. Main asset is money which is coming in, which was getting diverted, and they were doing cash business. So what the lenders did, whatever money was in the account, they simply usurped it. They said, we have some clause in a contract, we are just taking it out. Lenders were advised by their respective lawyers that, look, if you do this, tomorrow somebody can say, but there is a moratorium. So they said there is a stay. We said, look, stay doesn't mean moratorium has gone away. Tomorrow, what if the stay is lifted? Then how do you answer these actions? Lender said, we are willing to take the risk. Money is lying in front of us. Tomorrow, this money will also be gone, so we are taking it. So they took the money. Company came back into CIRP because the appeal was totally without any merit. NCLAT dismissed the appeal, company was back in CIRP. Now, RP said 6 months ago, insolvency commencement date has happened. Publication is already made. So how will I get claims? So RP issued one more public announcement, citing this order of lifting of stay as the date from their 30 days. But now what has happened is that this whole dispute of whether moratorium is there or not there, which is why I said there are 3 separate orders. And on this, there is so much argument that has happened. I had only appeared at the NCLT level. Now matter has gone to NCLAT. The question being, was there moratorium at that time or not? Lenders are saying there was no moratorium because you said operation of impugned order is stayed. And in fact, there is so much, courts are also at fault because NCLAT should not pass like one line order. They should have said RP to remain in control, but COC not to be constituted. Should have said something. They passed one line and created this confusion. And now everybody is fighting over it. And it's not just that, it's not just the banks. During that time, company has made almost more than 100 crores of related party payments without approval of COC. So lenders are saying, if I have to give back money, everybody has to give back money. So how do you bring all that back? It's like you can't turn the clock back. So the easier way is to simply follow the code. You issue public announcement, and because if you don't do something like this, and suppose I'm raising this issue, let us say form FA has come, settlement agreement is there, but something happens and one of the parties back out of the settlement. You have not given public announcement. So tomorrow court, everybody will ask you, why did you not give public announcement? Your job was to tell the court. Why are you siding with the promoter that there is settlement, not settlement? That's their headache. They should mention the court in the matter quickly and get the matter out of insolvency. So that it depends on, there's no one size fits all.
Case to case, we have to decide.
Case to case with promoters who have some credibility and who genuinely want the company out of insolvency. I would also advise that you know them best.
Such promoters are not just.
No, I mean, I would say they are.
And promoter
possibility. So there are still wheels within wheels.
So the point is,
Just add
Yeah,
one more to what you see. See, I think in addition to all of that, recently when a 12A was filed in a Cisco. One interesting thing the NCLT said.
Sir, little louder. They are not able to listen.
सुन नहीं रहा.
So recently when a 12A proposal was filed in Cisco matter, right, very similar to that, where immediately after the NCLT. NCLT made a crucial distinction between a 12A proposal where in the NCLT said that unlike in case of a 12A proposal with a 90% COC, in case of a 12A proposal prior to COC constitution, the NCLT has all the discretion in the world to decide whether or not I should accept this 12A proposal. So in such a situation like that, just adding to the risk that Vishnu pointed out, what happened in Cisco, right? All the lenders were on board, but the NCLT took its own decision to say that, look, today you have settled with FCs. Tomorrow some OC will file the application, again the company will go into insolvency. So on that ground, I'm not allowing this FA and I'm also not excluding this time period. In a situation like that, if we are faced with a situation, you are in a situation where CIRP is there, nothing has changed, but the public announcement has also not happened.
Yeah.
So that's one other risk maybe, because in case of a situation like this, you are sort of gun jumping and taking a decision that a 12A proposal is already accepted.
already accepted.
NCLT has the jurisdiction to not accept.
Because somebody can back out also. You see it where they will say, "Uska funds kahin aur se aa raha hai, kisi aur de raha hai." You have not seen all that.
See, as RP,
but I need to, the intent of the lawmaker when this IBC Miller's report. But this is a commercial law, so we need to take some practical view. So yes, where there are ample of applications pending, where we are aware that the same company's 5 applications are there this is a risk. But this is the only application, and company is doing good. We faced one of the case where it was a listed entity. The promoters were wrongly guided that it was an initial IRA. So they were wrongly guided on IBC, that IBC awareness was one of the matter admitted. They were guided that what will happen, we'll take it to appellate of appeal. And we went to take a charge the very next day of the thing. Then we came to know that this has happened. We guided them that if that is there, settle it with him within 3 days. That was the case where the fight was there. Actually, in that company, the promoter's brother was a ex-staff member and he had put some book entries in the books and had left the company. And that was the key point of dispute and matter had got admitted. And they thought that at length they will clear it out. But we helped them in 3 days' time, negotiations, brought them thing, 12A thing, FA form, FA filed. The courtroom we fought, where the owners came on the RP stating that you are responsible to take this call. I'm not telling you. Shawat was the bench member. Bench 2. He clearly said, Mr. Kandar, I am not here to write this. I said, sir, then I will have to follow what the IBC code says. I will not be able to hold this application. So he said, you take your call. And 4th day, he was only asking me what you did with a tone, different tone. I said, sir, I have done my duty by sending it. As a charter, as a IP, we know that our duty is to send the application for publication. If publication house does not publish, the owners does not come on. The matter was only of a day in that case. But yes, you cannot use this where you know it is going to be prolonged and you have a doubt. You have to play. But as a RP, I always feel that practical views needs to be taken case to case basis.
And this thing where you will actually, for the FC, when the FCs have withdrawn funds from the company in the duration when they were staying. What is that case? And I mean, ultimately, what is the direction of court for?
Still in appeal. At order, final judgment is awaited. City Networks.
City Network, actually order is there, they have to return the money. And
No, order is there of NCLT. NCLT said you have to return the money. It has gone to NCLAT. In NCLAT, court said, okay, they stayed the order of NCLT, but they said put it in a fixed deposit. So banks have already got the money back and put it in a fixed deposit with themselves. They've kept it aside. City Networks.
SITI.
SITI.
Sure, I'll share it with you afterwards.
Sir, Z group, na?
Z.
Yeah.
And in that one sentence is that order is that stay is not a withdrawal, so that RP duty continues. Hey, but that sentence is very important. Stay is not a withdrawal, RP duties, IRP duties continues.
IRP duties continue, the stay is applicable to CD and the RP, but not maybe applicable to the school management and SCs.
It is very important. So where anytime you get any stay order, first of all, read that city cable judgment and start acting on it.
Right, whether it is action or
They
not.
stay on the constitution of the committee, but I actually have to continue.
In fact,
Process.
they have dragged the RP in
But there
and
is-
passed a lot of remarks on the RP also.
Clean direction that who's
In one of my cases,
and who's
what
expected.
is the stay? That there is a stay on resolution.
City network.
I said this is a stay on
So
resolution.
better to read,
My
because
senior.
if you decide if it's stay, then RP is relaxed, right? Stay, but uske
And the-
RP is in trouble at times because.
Yeah, I think a lot of time
that is-
because
There are funds.
Because they had some representation, they could rectify it.
see, the kind of scenario we now face these days in multiple cases and the way the things get litigated, I think a lot of time as RP, there's a theme like as Snehaji, you were also mentioning, we need to take a practical call. But we need to also understand as RP, I am not a adjudicating authority. I am being guided by a law. Unless there is a court order, unless there is a direction to me specifically, to act in certain manner, I should not be deviating by my emotions or by whatever thoughts I may be having. That may save, some kind of litigation or risk on the RP particularly. It may happen in certain cases that, okay, the business may face, certain issues by a public announcement. People may take a negative view on that. But I think if at all in future that is cleared by the court, the company can clear that negativity by issuing a fresh public announcement by their own. Nothing stops that. But as RP, we should be mandated but what law says, and unless there is any particular order specifically, we need to be guided by that.
I agree. I agree with you. One has to go by IBC code. We cannot deviate from the code. But sometimes if some small cases are there, where the things are there, the laws are being taken. I just wanted
So-
to-
So let us act in a way that we are documenting.
आगे बढ़े अभी नहीं तो क्या है अपन
आगे बढ़ते। Claims man.
शुरू भी नहीं है
So I think, we can, this was just the basic process of, you now, I think the key thing which has changed now is that Supreme Court has said you have to have a claim form. Without a claim form, you can't admit the claim. So if you know there are two things, primary factors here. One is, that there is a claim in the books. So our advice would be that, and I'm sure Rahul will agree, that you should write to the person and show that you tried to get a claim form. Because there are one line of judgments which also say that when you saw it's there in the book, then why have you not admitted it? But there is one more line of judgment. The Supreme Court says if there's no claim form, you don't have to admit it. So this is what we do. And despite that, if you don't get it, then you tell in your information memorandum that, look, there is this claim. But I have not admitted it because he's not filed a claim form. But you put the resolution applicant to notice that there is a claim. So, if it is a claim that has to be dealt with, if there is liquidation value, etc., then the bidder can take a call because bidder does not want litigation. So if bidder sees that there is 100 more crores to be discharged, he'd rather take it into consideration than, fight that, no, there's no claim form. So those technical aspects bidders usually don't rely on unless it's a very large claim. Then of course you will want to litigate it out. So that I think is the key aspect here.
Just to add, one way to do it is, generally what we do in the first 14 days when we call for claims, we generally, scan through the trial balance. If there is any, financial creditor, we feel that, might be ongoing creditor, we write to them that, okay, this is a public announcement, you need to file your claim by that day.
That is now mandatory by email, no? By the claim regulation itself, it is there.
MC also, we can have a check,
You don't get the books of accounts and their email IDs. You are helpless.
Yes. So, but we need to show some effort have been made by us, even though for example, SBI, I may not be knowing which department in SBI, but if I am having any other email IDs which may, substantiate that I've taken enough effort, I should be doing that.
But in certain cases, suppose. But still claims are coming.
Thank
Then what should we do with it?
So that is,
That seems to be genuine claim. Means
Yeah.
supposed to be, genuine. So how do we?
every claim need not be in the books.
Yeah, that's the.
So the idea of claim verification is not only to look at the books. More often than not, if it is an operational claim, There can be many situations where it's not in the books. Not just in the balance sheet, but it's not in the books also, right? Possible.
Many times there is no books only.
There's books are not kept properly. So you will have to see that whether the claim is let us say that the key thing would be, has the claim, is there a contract, was the service or whatever goods accepted or given? There is no, I mean, one-sided information is typically there. Claimant says, yes, there is contract. Claimant says, I have given goods or services. There's no dispute. You will create record by asking the management that according to me, it's there. I am seeing there is a contract. They say that goods were supplied. Goods will not be lying around still. They may have been consumed. So you'll have to go by the claimant's version. If there is nothing to controvert it, then you are bound to accept it. You can't, your idea is to play a neutral party. The idea is not to reduce the number of claims of the company. At the same time, the idea is not to go out of the way to assist the creditor in, because then other creditors will say, why did you accept it? So I think there is the Supreme Court, I think all of you are familiar, Supreme Court has repeatedly clarified that RP's job is to collate the claims. You can't adjudicate it. So there is any hint of a dispute, then you will put it in that category, whatever you may want to call it, unverified, disputed, etc. This is the dispute. If there is ongoing dispute, then it's very evident. Then you don't do anything. If there is no ongoing court proceeding, but still there is a dispute, even then you cannot admit it, because if company is telling you that I didn't do this, of course, if you feel that what company is saying is just for the sake of, not admitting the claim, then there are cases we have advised RPs that look, it doesn't add up at all what the company is saying. Why do you want to invite trouble on yourself? Because ultimately the claimant is not going to keep quiet. Claimant will say, there's not a shred of evidence in what the company is saying. There's no basis at all. वो ऐसे ही लिख के दे रहा है कि show me some document where he has disputed this before. Anything to show that I have not given the service.
But then why he is saying is that this is not in books of account because GST are 1 year not produced. It is not
Right.
required for the
Right.
GST and most of them the basic and the company payment why do I pay the GST?
Right.
To the issue of proper mind.
Right.
Therefore, it is not required either in my book.
Correct. To avoid the tax liability.
Nor in the, on the website of.
Right. Right.
In those cases, there is a problem to admit that the requirement of regulation. One is the document which he uploads on the.
But sir, that is from a tax compliance perspective, right?
Regulation also requires you to verify.
No, I'm saying, see, let us say I have given some service to the corporate, right? I am supposed to, or corporate debtor has to pay GST. That I have given pro forma invoice with some arrangement to avoid it. Question will be that if you have not paid GST, does that invalidate the underlying right to claim? I would argue, no, it's not. I would argue, yes, there could be a separate implication that there is now a GST liability which is separately, that could be there. But there are two things. One is that have I performed the contract and given you a service or goods? That if that is there, then I mean.
The contract also requires.
But then what happens? We as an RP also, where the banks are not paying or when the creditors are not paying, where we are raising this. Otherwise, what will be the situation? I will have to pay GST from my pocket.
No, but you're saying invoice is there. GST invoice is not there. I appreciate. So GST invoice. So you can ask the question. I am not saying that. See, if you want, if the idea is to, you don't want to admit this claim. I would say that this is valid reason. No, because that is always, let's be realistic. I mean, that's also there always. So if the question is, like, I'll give you an example. If this claim is, say, in a CIRP of 500 crores debt, if some person has filed a claim for 1 or 2 crores, and I would advise that you just go ahead and admit it. You place it before the COC that this issue is there. No, it doesn't. It doesn't because no, it doesn't also because the question is that today whose liability was it to pay GST? Corporate debtors liability. The liability was
As a single, maybe 1 crore, but as a district creditor like that.
So then you can't admit, that's what I'm saying. Because, of course, if that is the case, then you don't, because ultimately there is also a risk, there's also a loss of litigating the matter out.
So it depends on case to case basis,
Yeah.
but lot of time there is an underlying contract. As per the contract, the person is liable to get certain money, right? He's supposed to get certain money which has not been paid. He's just trying to avoid his tax liability and giving a pro forma invoice. Lot of time we need, as RV, we can take a practical call that okay, there is this liability. Basis the contract, we understand there is a genuine liability, and basis the pro forma invoice, I admit it. But in certain cases where we feel that there might be a risk for the larger stakeholder overall, there we may, in order to avoid it, we can create this as a reason. I'll give example at other places also where, since sir was mentioning, what if the liability is not recorded in books of accounts. In one of my case where I'm doing, there is not a single data we have received pertaining to the books of accounts. It's a clean slate for us when we went into there. Not a single employee was there, no one from finance, just an empty office which we have got into. Now, when we made this public announcement, we have got claims from 5,000 to 6,000 employees, right? I don't have the HR data, I don't have payroll, I don't have whether the person is actually an employee or not. And they have been sending emails, sending claims. Now, as RB, what all I need to do, in order to protect the sanity of the law and my risk as well. What we did is we made a list of all the claims. We uploaded it, with IBC, and also we have to create a new website because we did not have access to the website as well. So we created a new website, uploaded it there, made a public announcement that this is the website for all the matters, for all the communications related to CRP. The second thing what we did is for all the employees who have made those claims, we have asked questions like, show me your 26 A's. In the 26 A's, there would be, if at all the salaries or TDS would have been deducted, that would be showing there, right? Or form 16, or last communications emails with your manager. So with that, we are trying to take a practical call that, okay, this person may have worked till this date because this is the last communication he has made or it has been acknowledged. And basis the latest salary slip, some understanding of that, okay, what would be the claim that we are, arriving at, communicating it to the employee and updating in the website as well. So
best judgment.
Best judgment.
These are the things based on the documents. When you are physically in the office of the city, this employee is working for the entire group of companies. Which part of employees है ये company में employees जो है X में कुछ Y में. So over you are aware. You are sitting in.
जो different entity में है उसका फिर मैं admit नहीं करूँगा.
Employed with the city.
Correct.
Form 16 employed with the
city.
But physically he is not working for city.
No, because by that date he has already resigned, or since they were not coming to office, I have already made a communication that no pay.
Continuing, but if MSME company, employee work for the entire day. Which employees will be work, they allocate the employees.
Correct, but I need to see where his payroll was. If his payroll is with the entity, then I'm supposed to pay him, right? Even if he's working for other companies as well.
You are dedicated worker for this company.
His privity of contract is with this particular entity where I am the RP, so I need to abide by it. There is a contract with the employee and the corporate data. I need to abide by it. He may be supporting other group companies, but that is informal way.
Order of management of the city. You have a CFO, you have a group CFO, you have a group president, everyone is a group.
Yeah.
So they'll show you card as a group CFO. You are entity going to be
Sure, sir.
But for officers,
we can take break, you can yes and this way. Yeah. Because we are having and you are not having, so it's not. We can complete and then we can.
I will speak so you can have some.
We will give you 5 minutes. We all can take 5 minutes.
5 minutes.
Sure. Yeah.
Sometimes it may happen, the claim has been, the application has been admitted under section 7. For the particular city. Right? Now the banker who has already applied for section 7, say he has made a claim of 100 crore. Now I have asked him the document that you give me your bifurcation, what is the principal amount, what is the interest amount, and how you have derived this. So he said, boss, NCLT order है ना, you don't have the now you know आपको क्या करने का है? NCLT order है, उसने 100 करोड़ admit कर दिया है. अभी you don't have any jurisdiction to take my claim.
That's not correct.
That is not correct, but you know sometimes you face those kind of situations and
Sir, what you are saying is correct. No, like
That may be a situation, practical situation ऐसा होता है. Bank आपको bulldoze करेगा, but for as RP you have to have your documentation straight.
Sir, matter admitted to CIRP on a section 9, right? RP called for, so IRP appointed, IRP replaced by another RP. RP, when he came on the scene, he saw that as far as the books is concerned, the claim of the OC is not payable. So he initiated a dialogue with that, wrote an email, give me details. Details not given, right? So he wrote 3 emails. 3 emails were not responded to. So OC said, I will not give you any details. Very categorically, he said, I will not give you any. So OC said, I cannot admit your claim. And he said that I am reducing your claim to 0, right? Matter traveled to from NCLT to NCLAT. So NCLAT has taken a view that because there is an order of NCLT on a section 9, that OC's application, the matter was admitted. So if RP is not accepting that claim, he is sitting in judgment over the adjudicating authority, and therefore the RP is in wrong. And RP, the NCLAT has viewed this very seriously.
Analyze the RP and pass the structure also.
So
No, but sir, but
so what is important is I said very seriously.
I said very seriously.
but you are talking about a question of rejecting the entire claim.
Rejecting the entire thing.
But what he was saying is a component.
It's a component, yeah.
Naturally,
I'm talking
you
about-
cannot reject the entire claim. If you do, the CIRP falls.
Sir, but when the RP, so I was involved in that, so I can tell you, I am aware of the facts of the case. So when RP worked on the claim.
It is a different case.
Different.
No, I appreciate.
So when RP worked on the claim, he came to a conclusion that basically funds are receivable from that OC. So basically, the CD has to receive from that OC.
Based on the contract.
So based on the contract. So where is the question of admitting the claim at all?
No, but you can't set off.
no,
You can't set off. Even if
let the
there are-
RP make a claim for the receivable. He tried to recover that
cannot set off.
receivable
So same
and
party
admit the
can set
claim.
off. Same party you can set off.
No, you cannot set off.
There should be a claim first in the book.
No. So,
For me to
yeah, if there is no claim and NCLT has made a mistake, then I mean, I would think that those issues are few and far, but if there are, then you'll have to go to NCLT and report this matter. I mean, I can tell you in a matter that he was doing also, the original operational creditors claim was suspect. But it was such a large case. The banker said, please drop it. Because the bankers
He
didn't
did
want
not
the,
file a claim. The applicant did not
he
file.
didn't even file a claim, forget it, I mean, not forget suspect. And we all know that that claim was
It's
just
bogus.
set up, it's bogus, it's rubbish. It was in fact a chartered accountant. The claimant also was a chartered accountant.
So just to add to what we.
We have a similar recent case.
Yeah.
Where IRP had admitted the claims. Okay. And he was replaced by RP.
Yeah.
And RP, so it's a real estate matter. So the previous RP had admitted a claim to the home buyer. Whereas against his fees, the flat was allotted. So he's operational creditor.
Yeah.
So the new RP reviewed it, said and rejected the claim. NCLT has given the order that RP has no right to review one's accepted claim. He should have come to adjudicating authority first, and we would have directed the same.
The IRP's claim, you mean?
IRP had
Yes.
admitted the claim, and IRP was replaced by RP.
But that is the
New
law, sir.
RP.
You can't review the claim.
But the claim is completely.
You will
wrong.
have to file an application.
Yeah.
You can't review.
So that was the case. Now they have given this order. Now based on this order, can RP move ahead in filing an application after this order on the same matter?
For taking the company out of
And the
insolvency.
case was like the chartered accountant being taken as a home buyer is because of which the claim previously he had rejected. The matter was decided that it has been rejected because of this. So in favor of the chartered accountant it came. So now the RP is bound to take him back into the home buyer's claim. So can now RP go to the same bench and say, okay, this was your order, I accepted your order, have put him in the case, but my point that I am going to say is that he is not a home buyer. His claim has been filed as a home buyer, which was accepted by the previous IRP. He is
You
a
want to reclassify.
To reclassify.
You will have to file an application. Of course you can.
You can.
That's what you should do because you can't do anything else.
Also, no, the one point of thought is that what is the RP's role? RP's role is to accept the claim if now bench has told why he is arguing in reclassification that other stakeholders are not taking. So either he takes this matter in COC and any of the COC member goes and files this application. That would be a better stand to take than the RP going himself.
So generally, what I think might be a right way to do it here, subject to what Vishnu you say. So let the RP. So RP's role is collation and verification. It's not adjudication. We are clear on this. So when in case RP has a different view.
Between the whole verification and adjudication. See, verification at time when I have a doubt, I may object to it or I may call for further information. But where there is, what is the thin line or what is the line or difference between the verification and adjudication? That is some real, it is easier said.
I think so. Based on document which were there, the IRP, he is wrongly classified as a financial credit. But the document was there, he has given a charter for professional service, so it comes under operational debt.
Right. It should be a Form B, so Form B ownership. So verification is basically, whether the claim was filed in right form or not, whether the amount which is claiming is abruptly different from what was there in the contract, whether he has deliberately added any penalty or interest, which was not in the contract, so those kind of, basic checks the RP need to do. In case, in situations when it is a matter to decide whether it would be a particular claim would be a, related party or not, or whether it is a FC or not. In those cases, that the RP do not have adjudication authority. It's a NCLT who can adjudicate and decide.
Yeah, but if I see that the goods are not come, only bills have come, or some bogus, then who decide? Whether verification wise I find it is okay. But if the goods have not come, or it is a very inflated claim filed, then what is the role of the RP? Whether he should blindly accept or he should verify. If you try to verify, it's all okay.
So let RP ask questions to the creditor as well. That basis these data, I feel the claim is different, or I feel the amount should not be this much. Let the other party, give those justifications, and basis that the RP should, decide a particular amount. If now the creditor is aggrieved that okay, my amount should have been more, the RP is not has not admitted it. Let the creditor go to NCLT and get an order on this.
Then what is the line of difference between verification and adjudication?
So it's like. Sir, you mentioned that.
Right now, the case which I discussed right now about 100 crore claim, which I said that they said they will let us, you don't have any right to ask. It is a case of invoking the guarantee by a subsidiary company, holding company. And the holding company has already admitted in this particular case. So in that case, my question would be that because the interest and penalty component start only once the guarantee is getting invoked. I wanted to know that thing only, that when it was invoked and when the interest is charged, whether it is as per the guarantee document. So that was the issue.
I think the key difference between verification and adjudication, if I may say, see, as a liquidator, you have to adjudicate, and the word is determination, right? The word is you have to determine the claim. You cannot say, see, as an RP, let's take both examples. You have, in your case, the claim is, say, payable. The claim is payable. Your question is about interest, about default interest, etc.
Volume.
So then you will take a very safe route. You will say that above this, I don't have 100% certainty. This is unverified or under verification. The rest of it is verified. That's a very usual approach, and NCLTs will not question that approach because ultimately the RP has to be satisfied with information and documents. The example that he was saying is a little more difficult to address because the CD has admitted and accepted the invoice. Let's say it's also in the books, but he finds that there is something amiss. Then you will have to ask those questions. And if those questions are not to your satisfaction, then you keep it under verification and you file an avoidance application for that. The fact that you file an avoidance application can be reason for you not to admit the claim because you feel that although everything is fine, there is something else which is underlying, which is either an undervaluation or a fraud or something that has happened or an extortionate transaction. On the face of things, everything is fine, but I can't see where is the asset that the person has bought.
We did the same thing in one of the claims.
Yeah.
Where the CD was a builder and developer. And the bill which we received was CRM, this code role and HR role. Now builder has nothing to do with CRHR role. Secondly, the place where the goods were delivered, the site has not been closed since more than 2 years.
Right.
So it was prima facie an adjustment of this thing only.
Yeah.
Bill only.
Yeah.
So we just put it in a open transition application.
Yeah. So that is what you would have to do.
I'll give an example of, to the extent, we may go in order to verify. So there was one of these Reliance Group companies under IBC. There was the lender's debt was around 550 odd crores. There was one of the Reliance Group company, which is into financial services. They have given ICDs to this particular company. Now, by name, it being both Reliance, it's very clear that they are related party, right? Even if they have given ICD and they are financial creditors, they will not be having a voting right. But as RP, somehow, we need to, get into more details and, we need to see substance over form. And this particular company, in order to treat them as a related party, so the regulation is very clear. How can a particular company can be a related party? Only if there is a more than 20% shareholding. While this company was having 19.8% shareholding. The second is if there is any common director for the group. But in both the entities, it was a diamond structure, wherein in both the entities there are only one common directors, not two. So there has to be two common directors actually, as per the law. Third was whether there is there is any management authority of the other company over others. It was also not there. Both are clearly distinct companies. Rather, one was already into insolvency, and the one which we are RP just got into insolvency. Then they may say that okay, it's under administration process. They are not managing us. So those are the situations where we knew clearly it both being a Reliance Group company, both are related. It was difficult for us to prove on paper that okay, these are related and hence they would not be having voting right. So the question is, as RP, should we just leave it there that okay, prima facie there is no substantive evidence that they are related, and hence we admit them in the COC and let them have a voting right, or what we did was we started digging deeper into we did two things. One, we started asking them a lot of questions. Then why did you give those loans to this particular company? Share the board minutes, share the like who was the author signatories in those board meeting, what was the sanction letter. So we called for everything. We started digging deeper in terms of all the annual returns both the entities have filed in last 4-5 years. So through that, there was one common connection which we came that the CFO of that company was authorizing certain transactions of this company, which in a way, also triggers one of the clauses in related parties that the other company has, substantive control over the subsidiary or not. So through a lot of digging, which may not be, directly available through public data, we then created a case that, okay, this is a related party. We communicated all those observations to the other company. Luckily, that was under also administrative process. The person knew that how the IBC works. They acknowledged it, and they did not push for claims as a as a independent COC member. Rather, they agreed that it's a related party. So we closed that there. So the line between verification and adjudication, is bit blur. But as RP, we need to dip deeper, and we need to see whether what is a substance over form. That might help us sometime.
Does it independent?
That's
So to put it differently,
you did not allow him
In the COC as well.
You kept it provisionally admitted.
Right.
sir, to put
Snail sir knows it very well.
differently. To put Pravinji's question differently, so RP is not supposed to adjudicate, right? He's not supposed to adjudicate. So what is he not supposed to do so that he does not adjudicate? You know what, again, still.
You can't take over functions which are adjudic. What he is doing is fact finding.
Yes.
But you are
That is
not-
part of verification.
And I'm questioning him.
That's part of verification. Let's say claim for damages. Both RP or liquidator can't adjudicate. Because that's a court, only a court in Indian
Court has
law.
to determine the.
Under Indian law, even liquidator damages, you have to get a court order under Indian law. Let us say there is some dispute going on, but before parties could file a case, matter has gone into CIRP and the other party has not filed the case. But clearly there is a dispute on the quality of goods or services. You cannot adjudicate it. In fact, the law is that even NCLT cannot adjudicate. Otherwise, the section 9 would have gotten admitted, for example. NCLT says we are summary jurisdiction. That is not IBC's realm. So you can't adjudicate that. But that same thing in liquidation, if this example were there, the liquidator's decision that look, there is clearly a dispute. In liquidation, that is why the moratorium relaxes a bit, right? The liquidator can take permission of the court to continue proceedings. It is possible to have arbitration against company in liquidation while liquidator is going on. Because then if you have claims both ways, liquidator can always take permission and invoke arbitration and there can be a claim and a counterclaim in that. Because if a liquidator takes a decision that this is a disputed debt and I am not accepting it, that results in rejection of the claim. But in CIRP, it only leads to side pocketing it into unverified or disputed. You don't have the right to accept or reject. You say, I'm not doing anything. But a liquidator's rejection is conclusive rejection. There is no claim after that.
Ma'am was having a question.
I was asking the directors, you have to have 2 directors between the 2 companies.
Correct.
Suppose you have got 2 independent directors on the board of the 2 companies, what happens?
So I think the law says 2 directors.
But independent directors, would that condition still apply? Like they are independent, but they are. on the-
Even if there are 2 common independent directors, we can make a case that, okay,
They're related.
because the law is clearly says 2 directors, does not say, executive director or independent
I
director.
suppose they were directors, suppose, in the immediate, when taking over happened. But, about a few months back, would that still be?
If they have resigned before the initiation date,
Maybe about a year.
yeah, then should not be considered actually.
So we move ahead.
I can just add one anecdotal
Adjudication and verification. In CRP, verification is done, and in liquidation, adjudication is done by the. So, just stretching it little bit from the matter that we say, where IRP has admitted a claim. That means IRP has verified the claim. It is not adjudication done by the IRP. Then why can't the RP review it? If adjudication is not done, the review on the verified claim cannot be done. Is that so?
No, that is not, I would say that is not because of the difference between verification and adjudication. IRP and RP does not have superior claim verification powers than IRP. IRP has claim verification powers up to a certain time, then RP has claim verification. But claim verification is the same. Both of you have exactly the same powers for claim verification. Therefore, if IRP has verified something, you are not generally in law, only a superior authority can review or overturn an earlier decision. So therefore, you can't do it, the court says. Otherwise, it would lead to a situation where people will remove the RP and bring one more and say, "Ye sare claim hata do." That would all happen.
One of the cases. There was fraud by the IRP. If this action is also initiated, everything is there. Where a real estate matter where 90% stake was constituted of home buyers, 10% was given to PSU bank. Whereas when the RP came, he revamped the things. 70% was bankers and 30% was home buyers because most of the home buyers were bogus home buyers. Now, in such a scenario, your UC itself is a challenge. So there, if the RP does not take a cognizance, if there is a change due to this fight only, the change has happened.
No,
And
you can
NCLT
certainly.
but NCLT has not treated in the order. There are some orders where NCLT has directed the RP when the change is happening that you reconstitute the COC and re-verify. Now the RP has a right to re-verify.
You'll have to file a separate application and ask for this order. Yeah.
I think let him proceed, otherwise.
Add one, if I could just add one anecdotal thing about this verification versus adjudication. There was a session on this conducted by IIM and Bangalore. There, one of the speakers made a very crucial distinction. What is the difference between determination and adjudication? If something is coming from the document, whether something is coming from the document, that is verification. Whether something ought to come from the document, that is adjudication. To give you an example, right, in one recent case, there was a loan agreement wherein there was a simple interest of some 20% and a compound interest of 50% that was being charged. The question was whether or not this is admissible. What the NCLAT said is that, look, from the document it is coming that it is chargeable. So as the RP, you have to make a determination that it is admissible. Whether or not that ought to have been in the document, whether or not that is in violation of RBSE, that is adjudication. So the difference between adjudication and determination is versus ought to.
So just, yeah, there are many situations where this takes many complicated turns. So you will have to look at it on a case-to-case basis. But I mean, I think that is why any claim verification is one of the areas where, you know, we frequently get involved as lawyers, because there are a lot of cases where claim verification is something which is more than what meets the eye. There might be laws surrounding those kinds of claim verification. As a non-legal person, RPs may not be aware of. So it is not simply adding documents and comparing. Sometimes you could go wrong. Sometimes, see, always also to err on the side of caution and say, no, this is looking a little bit more than what I can easily accept, so I'm just going to put it. But that also won't help, because you'll have a huge bucket of unverified claims, which also will show that the COC will ask you, why is there such a large amount? Why don't you either admit or reject? You do something.
Tomorrow it will have a different.
It'll have an imply. So therefore, you have to.
This under verification, till what time the RP needs to take this call?
There's no time, sir.
So and the resolution plan is already there. Now that is
The resolution bidder will take a call on how to treat
So
it.
he can keep under verification even during resolution.
Yeah, but then
You will have to
ultimately what
justify it.
happens?
You will have to justify it. If you actually don't have information, how do you verify it? That is your.
But then ultimately, what will be the fate of it? You know, resolution applicant will come, he will not consider that, or he will consider that.
That depends on him. I mean, see, for example, let's say you're a power company. There is somebody who has a PP, who has a 700 crore claim. You have not admitted because there's no information. At the same time, the bidder may not want to completely burn those bridges. So bidder may say that, bidder may put in some provision that, look, if this is admitted at any time between my submission of my plan up to NCLT approval, then I will pay it in the same way. Because, but bidders will still need an order of court. He'll not go, they're not so generous that a rejected claim he will go and make payment, but he'll make some provision.
No need for RP to go in a rush when the plan is being passed.
No, in a rush,
classify or either accepted or rejected all the claims.
See, the regulations say within 7 days of getting the information, you have to admit or reject. So if you have not got the information, then periodically you must follow up for that information. And if you have not got it, you have a justification why you've kept
I need
it
to
under
create those documentation.
Yeah, you'll have to.
So
the paper trail will have to be there.
So I'll give an example. Beautiful one which we are doing now. Seven Hills Hospital. It is built on a land which is owned by BMC, and the building is owned by the lenders. Now BMC, when they came initially, they said the IBC and all this does not apply to me. I'm a municipal authority, all those things. And later on, they filed a claim as well. The claim was a very bubbled amount.
Claim for what? Land or?
Claim for lease rent, property tax, penal interest on that. So they have filed a claim which was, a very bubbled amount by certain calculation on the capital value of the land, which was way beyond the municipal laws. They have filed that claim, and they are a critical party for any resolution of this hospital, because anyone who's coming in, they would be the landlords. They have to be abide by that, right? So, but in the past, the promoter had made certain communications for the calculation of the lease rental, which was so, and the difference was quite high. Now, if I admit that claim, the promoter will create litigations, will create issues. If I do not admit, BMC will create issues. What I did, I just put it as under verification, admitted at 1 rupee under verification, right? Now, whoever is the PRA coming, I've highlighted that, see, this is a critical stakeholder. Whatever may happen, you have to first get their approval. There's a Supreme Court order also, because since they are the landowners, Supreme Court has said that they have to approve it first before it can be approved by the COC. So we have highlighted to the PRA. Let the PRA speak to BMC. Let the settlement happen out of the resolution plan, and in the plan I get the values which is payable to the COC members. So until date, till the date of calling for the plans, I have not admitted it. It's just still 1 rupee. So that can be one way to.
So 1 rupee admitted. Technically, you need to put it across slightly. Because I came across some case law, I don't remember, where the bench was category law RP. That when you are presenting plan for approval and still you are showing the claim under verification. How can it be? Tomorrow I approve the plan, what will happen to this under verification claims?
So that's right. I mean, when you say under verification,
that's where so 1 rupee claim admission with a note on it that this is admitted for 1 rupee, but that this is because of
or under verification would be for some reason. Let the RP document it. Let the PRA cover it formally in the plan that all verified, unverified, under verification claims are being settled under this plan. And in case those are critical party, critical stakeholders, let him settle him out of court or out of the plan itself.
Same thing in EC.
My question is then only whether admission of 1 rupee is justifiable or not. In SR case also the same thing has been done by Satish. He is admitted.
That's 1 rupee.
Where there was a doubt whether that particular claim is admitted.
Litigation.
Or you keep it as under verification.
But Supreme Court has confirmed, sir.
Two of the cases when I just refer to my law form, they said, why did you admit it 1 rupee given? You should not have admitted it at all if you are not sure. So sometime it may happen that the 1 rupee which we
ultimately call is to be taken by us. Case to case basis.
But whatever call you, everywhere you are challenged, na? Either way you are challenged.
So there is honestly, I don't think there is a significant difference.
Now that competent authority will be a part of the COC observer, so they will always come and fight in the COC. So now you're required to call a competent authority.
Yes.
In the COC meeting as an observer. The BMC will be a part of those observer teams.
So
right. So they're there. Yes.
Yeah. Come and fight in the COC meeting.
But you need to. So it was there. It was the same situation here. They were fighting कि 1 रुपये में क्यों under verification क्यों, you have to admit it. But then you have to explain him the situation that, see, if I admit it, then so it's more of a managing the person actually. If I admit that these are the risks, if I don't admit the risk, that this is how we want to do it. Let's align on a plan of action so that they are also not losing out.
It is managing the stake, na? How it is managing the person? It is a mere real stakeholder, na?
Right.
Sir, if the resolution, Rahul, if the resolution plan is coming, so we used to do something different. What we used to do, while the plan hearing is happening, all these people, whose verification, we all make them the party. So we have kept them under verification. We make a party to the resolution application itself. Most of the time, these verifications are statutory authorities. Okay, and then we make them a party. There is already a treatment given in the plan. Now, if I say that statutory authority so in the plan I am giving only 1 rupee, I have already made him a party. He does not appear. Tomorrow he loses a chance to come and fight on these grounds.
But that is not required. That's not required to make them. Whether the law is clear. The clean slate principle will take effect regardless of whether they are a party, not a party. That's not required.
Yeah, we say many resolutions.
No, see, litigations on claims will go on years after plan is implemented also.
Plan is implemented.
So that it is going. I mean, but
this rainbow
Ocean Power was a case where ultimately it was an operational creditors claim rejection application where it ultimately Supreme Court was hearing. I mean, the Supreme Court has set aside the plan for other reasons, but the application, the litigation was for
Basic
claims.
litigation.
It was an operational creditor for claims. So I don't think, because plan approval application, only party that needs to be, there is actually no party. You need not even make the RA a party. In fact, rather, I would say you should not be making the RA a party, because the bench also does not want RA to be talking all the time. In fact, they are more and more saying that you should not be speaking so much. It's the RP's application. There is a form. If everything is there, the bench has no reason not to
RA is
approve.
not required to be.
It is only for reliefs and concessions that RA is there.
Where we don't have clarification. We have addressed the mails, we have reached out, but they are not responding. And we could not conclude.
But
How to keep it open-ended, instead of keeping open-ended, if we make a party, no matter gets.
But I would say that what the Supreme Court, now I think 4-5 judgments, which is to say that it's not open-ended. Once the NCLT approves the plan, that loop is closed. There is a clean slate principle takes effect. I think of all the principles under IBC, that is the most accepted principle today. That there is a clean slate. After the plan is approved, you cannot claim. There are some exceptions to that which we can discuss, but other than those exceptions to the clean slate, very, very minuscule chance you will succeed because you have not agitated your rights or you genuinely don't need to be paid. That's also the case. You can't hold up the plan implementation or try to reverse it on that basis alone.
Many cases like when I'm not an RP, but I'm supporting a PRA, even though RP did not make the PRA as a party to this, and I know in that particular case, it would be litigated by an unsuccessful PRA. I would generally push the RP to make me a party so that I can also fight it out.
Yeah.
So
people are making MIDC and these were parties also parties so that tomorrow when they go for positions, I think the
Transfers, MIDC is not transferring you on that.
Even SEZ has the
They
same.
are very clear. This clean slate.
so if you make them party, I think it's better that they have not heard the in the
MIDC, GIDC, कुछ होता ही नहीं.
They say no.
Transfer for electricity.
Let them decide.
They don't decide.
Yes, IBC is not a.
Adani Electricity, they didn't file claim despite writing to them 10 times. And then they are sending
This
notices.
is a benefit to RA, not to the RP because application will delay. So if you are RA, you should insist that they make
I
MIDC.
think we will move to another
Yeah.
point of the.
Another point,
Yeah, I think we should move now. And simultaneously we'll keep having the.
my only problem
It's filed by IRC.
my biggest problem today is that if I give more specifics, there is one PRA is there and one auditor is there in my two cases. I need to weigh how I'm doing.
But they are in this side, they will not use this information.
Whatever is discussed here, is neither in anyone's.
No, I'm just joking.
And no one should use it for their personal gains.
I'm just
Get rid
joking.
of that.
Absolutely.
This is a free knowledge share platform where everyone is open to share their knowledge without having any
Experiences, basically.
reservation.
So let him take it.
So I think maybe one other issue is, I think we have touched upon some of these issues related.
My question was regarding the guarantees, basically.
Guarantee.
Guarantees which has been issued by the city. Now, some of the, first of all, let me start with a simple question. Whether the uninvoked guarantee will attract any claim or not, first. No.
No, you can't claim uninvoked.
It's a life guarantee.
Because the definition of debt itself says that even the future debts also include the.
No, see, you can file
it.
you can file it as a claim, sir. You can file it as a claim, but the claim is, see, definition of claim is even a contingent liability. Even a contingent liability is a claim.
It includes the claim.
Right, but because the guarantee, I mean, if you are the bank who has given the guarantee, because ultimately, then to that limited extent, whether you will even, I mean, you will have to come into COC, then see, so far as how guarantees will be treated, because these are, you're talking about performance guarantees, right?
Yeah.
Performance, financial.
So in a performance guarantee which is given for the benefit of the corporate debt, the bank can certainly file a claim. You will be unsecured. Yeah, you will be unsecured creditor at best.
So would it be different if it is a financial bank guarantee?
Even if it is a financial bank guarantee, I'm saying.
So uninvoked financial bank guarantee. Uninvoked financial bank guarantee.
You can file a claim.
So should we admit it?
Actually, it is a guarantee given by the subsidiary, holding company, who is a CD in my case. It has been given in respect to subsidiary, 100% subsidiary's performance for some government enterprise.
But what sort of guarantee? It's not a bank guarantee.
It's
just a performance guarantee.
Performance.
But performance guarantee, I mean, how are you are guaranteeing some monetary obligation?
No, backed by BG.
You are only putting in, it's infusion of money into the corporate debtor, right?
We have already given the FD over there. It is a 94 crore guarantee. The FD was been obtained, 94 crore. It has been deposited by the CD and again that the bank has given guarantee to the subsidiary of holding company.
This is bank guarantee.
No, you're saying this is a bank guarantee then.
Bank guarantee.
No, if it's a bank guarantee, then it can be accepted. Then it can be accepted. Invocation doesn't matter.
So guarantees would normally be continuing guarantee, right? So if they are continuing guarantee, if they have not been invoked earlier, they can always be invoked at any particular point.
Yeah, see, typically they get invoked solvency.
Once they want to invoke it, they know.
But during insolvency only, I have been informed by the bank that this guarantee period expires. You want to continue it or not? Because it is for subsidiaries performance, given for some contract, and whether you want to continue or not. So I have to take a call without COC because there is a take on COC permission. Then ultimately, I have to take a call, can you continue it and let it be as it is. We'll see.
So I mean, whether it is invoked or not has no bearing on whether you can admit it as a claim.
No, but in this case, the important part is that FD of 94 crore is lying with the bank. So there are two issues. One is they are not invoking guarantee because they are sure 94 crore to pada hai. They will.
Sir, cash backed guarantee.
So then, but that cash belongs to the corporate debtor.
No, but under the.
I will reject to continue their guarantee. I will attack and claim of 94 crore plus interest and blah, 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 everything.
But sir, that is the contract under which, that is between you and the bank. The corporate debtor has told the bank, you give a guarantee. The bank has said, I will give guarantee only if you create security. So that is the bank's security for giving the guarantee. You can't say that is corporate debtor's money.
So if this guarantee is given with a cash margin, can I not, in fact, can I not take cash margin back?
So cash margin is a bit of an undecided concept. Yeah.
If you cancel that guarantee, money will come back to you.
Actually, bank is.
But for example, that is EPC company, that is infrastructure company.
So that is where there will be a problem.
Another claim of 94 crores plus interest plus blah, 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 penalty, everything, which will be coming to me as a CD. I am inviting that claim. Because as on the date that claim is not there, it is settled position, the guarantee is continuing and let it be go like this.
Always share in your books as a contingent liability.
So guarantee can be continuing even after claim is filed. Guarantee continuing and claim filing are two different things. I am filing a claim because I have extended a facility. It's a non-fund based facility which has not devolved into a fund based facility yet. Once I pay the guarantee, then it becomes a fund based facility. Then I have a claim against the corporate debtor for having disbursed monies.
Then you have to file a revised claim?
No, not required. You will just, anyway, the claim amount won't change.
Then today, if there is no liability, on what ground would it?
Sir, it's contingent. It includes contingent liability. You don't have to.
So he will have a voting right also.
Yes, of course.
This contingent liability will be added to
Certainly.
the total payment according to the association.
Yes.
Very thin line between fund based and not.
Yeah, that is there. I mean, I'm just saying.
But that person has not yet parted with money, but still he
Ashwin,
will have
you wanted
voting
to say
right.
something?
Yeah, so on the cash margin.
Yeah.
So there's a.
Contingent liability, they make a note of it and they don't give that COC percentage.
So on the cash margin, what we were discussing is because of development issues. Generally, what NCLAT has recently said is that a cash margin for a bank guarantee that constitutes quote unquote a substratum of a trust and therefore does not form a part of the estate of the corporate debtor and therefore cannot also be considered as a security interest. So earlier, when a margin money was being deposited against bank guarantee, you used to file a CNG1, right? Now NCLAT has said that you don't even need to file a CNG1 because it's not even your asset, it's the asset of the bank, right? And therefore, now recently when we advised public sector banks on this kind of an arrangement, right? We draft something called a letter of appropriation set up, right? In respect to this margin money. The way it is worded, even in that document, is that this money that I am keeping with you, we don't even call it a security. We say that we are keeping it as a substratum of trust.
They have used it as a trust.
Exactly.
In the judgment, they have used the word as a trust.
Exactly.
This is the trust money.
Yes.
This is not your money, CD's money.
Yes.
Which is the judgment.
I can share. I don't know the.
is there, but it is very case specific because most of the agreement does not have this trust thing what you are saying.
No, but it's not only on the language.
This is the money in trust. This is not the city's money. The margin money which has been given. So therefore, there should not be any.
Then the claim should be the net of that.
account में पैसा ले चुका हूँ.
So there are
नहीं,
three types of.
इसमें दो चीजें होती है। एक तो पहले मार्जिन मनी जो है आजकल 100% होता है। पहले 20% पे ही काम करते थे। Suppose after the resolution plan of the CD is over, फिर बाद में इन्वोक हो गया तो बैंक कहाँ जाएगा? 20% के ऊपर कुछ करना
में आएगा ना उसका कंटीजेंट मैंने लिया है ना.
अभी 4 दिन पहले मैंने देखा था IBC there are 3 judgments. One is stating that it is the money of the city, you can use it. फिर बाद में नया judgment आया, it is the money of the trust.
Which is why I started by saying cash margin is one of the unsettled issues. So cash margin is an unsettled issue.
IBC laws में आपने
ट्रस्ट वाला अभी आया है recent, very recent.
Because from a banker's perspective, cash margin is not the company's money. It's not the company's money.
बैंक के बुक्स में liability है ना?
But बैंक के बुक्स में तो सीधा अपना अपना पैसा डिपॉजिट ही दिखाते
You're
हैं
saying
ना.
the guarantee is invoked.
अपने बैलेंस शीट में तो अपन डिपॉजिट ही दिखाते हैं.
Invoked and cash margin is also utilized, then the claim reduces. No, you can't get paid twice
What do you put a claim in such a situation?
for whatever is the balance.
Generally, banks would knock off.
Yes, yes.
They would knock off the
Yes,
cash
of course.
margin and balance amount.
Yes.
I can call back that cash because it is a
Claim
unsecured हो जाएगा पूरा बैंक गारंटी.
बैंक वही करता है.
इन्वोक होने पैसा इन्वॉल्व है। Not involved if the पैसा इन्वॉल्व नहीं
Sir,
है।
एक छोटा सा bank guarantee of 25,000 has created our company under voluntary liquidation on a stall since last 2 years. Bank guarantee was given for closing the, bank guarantee was given to MIDC for obtaining some MIDC permission and all this.
वो MIDC आपको वापस नहीं दिया होगा बैंक गारंटी को, फिर बैंक छोड़ा नहीं होगा.
बैंक बोलते हैं कि मैं अकाउंट नहीं क्लोज करूंगा और NCLT बोलते हैं अकाउंट क्लोजर सर्टिफिकेट बाद में मैं क्लोज करता हूँ.
But they give
तेरा 4 साल से चल रहा है सिर्फ एक्सेल का और
नहीं देते हैं.
No, नहीं देते. I agree. बहुत लेगो होता है.
बोलते हैं कि नहीं
वॉलंटियर लेना ही बंद कर दिया.
अभी हमने जो नया एक्वायर है करने का उसको बोला कि तुम ये इसके आगे इसमें तुम रखो, पहले तुम्हारा मनी रखो फिर हमारा गारंटी वापस दो, बाद में करेंगे. 2 साल से पड़ा हुआ है. Only 25,000.
In order to address issues like this, right now in documentation, what we do is that we do a couple of things, right? First and foremost, we make it very clear that this is the asset of the bank and not of the corporate debtor. Second, I mean, see, typically any kind of a security invocation document, the language that would be used is that in the event there is an event of default, we will invoke the security or something like that. Now we don't do that because our position is that this is not a security interest. Security interest can only be on the asset of the corporate debtor, right? So naturally, our position would be that upon the occurrence of an event of default, thereby leading to the devolution of a bank guarantee or a letter of default, the bank will be having the authority to appropriate or set out the equivalent amount of money. So nowhere in our document we give it a color that this is a security investment. We will just say, so all of this margin money is always kept as an FDR, right? A fixed deposit receipt. The language that we use is that upon the occurrence of an event of default, the bank will have the right to liquidate the fixed deposit asset and then use banker's right of lien. Because under section 173 of the Contract Act, the moment it's in the bank has a general right of lien. So now, because of all of this, now this situation, like for example, in case of a file of claim, right? Typically, what banks do is that if they have a claim vis-a-vis devolution of a bank guarantee, they don't even bother to file a claim. They just appropriate it, set off the margin money. Because now, I mean, like as Pam said earlier, it was 20%. We have now seen cases where the bank guarantee margin is over 100%. I mean, like we recently closed a transaction where the margin money was at 300%. So all of this claim filing issue and all, I mean, like the hope is that from now on that will not even arise, or the banks also don't want to come to a situation where this situation will arise.
So suppose you contract, SRA has terminated the contract. So one of the clause of that SRA LOI is rent is to be paid to the slums. Against that rent payment, if you are not paying, there was a bank guarantee given. So bank guarantee was based on the SRA letter of intent. Now that letter of intent is terminated, and SRA has invoked the bank guarantee. If now there is no contract with, I don't have any contract with SRA to pay the rent because my LOI is invoked. So do I still have to pay that bank guarantee?
Sir, bank guarantee is like cash.
It is no more a liability of.
But bank guarantee is like cash.
Hmm.
The moment you have given a bank guarantee, it is like you have given cash. The bank will invoke it, the liability will devolve. If your argument is that underlying contract is not there, you will have to initiate some mechanism of dispute resolution and get that money back. Or alternatively, you can go and try and get a stay from a court against the bank from invoking. The test is very, very high for a stay against a bank guarantee. There is one.
Go and file a writ, they say it is not a matter of writ, you file a suit. Suit will take its
No,
own time.
you can see, you have option of also going to NCLT, company is already in insolvency. But there is one test of, say, unjust enrichment, but that's a very weakened test. Generally, there has to be egregious fraud for any sort of stay on bank guarantee invocation. The primary test is that there has to be fraud. If the invocation itself has been done by fraud, or the bank guarantee has been procured by fraud, then courts can stay invocation. So therefore, I'm saying,
Now we have left to the new, whoever takes over the.
yeah, because bank guarantee, the bank has, the whole banking system will collapse if banks start taking a view.
Generally say कि भाई government के सामने हम लोग fight नहीं करते, we will face involved.
Yes.
Because our other guarantees will suffer.
You can't.
Nobody will accept that bank.
Nobody will accept that bank.
That's correct, yeah.
So people are like being differential. You know, basically in the IM also they are mentioning that this guarantee has been given to court or government authority, and this guarantee has been given to other people. I don't know, and some different treatment. I saw the RAs are doing different treatment for the guarantee which are given to court and given to others.
Court as in?
So they court, police, something. Authorities basically.
Statutory
Authorities. I don't know statutory. It's like police authorities or and these are authorities.
Okay. No, I mean,
but my understanding was that we were not admitting it actually. That's because it's not invoked. It's not admitted.
if they file a claim, you have to admit.
Right, if file, you have to admit.
Yeah, because it is a liability that is there, contingent. Definition of only concept of uninvoked bank guarantee comes that you can't initiate CIRP on the basis of an uninvoked bank guarantee because default has not occurred.
And how much do we accept as a claim? Because any which ways, it's not in.
The whole amount, ma'am.
How come? Because you anyways they have security.
Let me put it differently. Then by this logic, every term loan has to be recalled for the claim to be admitted.
No, there is a difference.
No, there's no difference.
There is a substantial difference. Now, when we talk about term loan,
Yes.
term loan is nothing but a sanction of an amount which you are likely to pay. But when it comes to a bank guarantee, you always have a margin or a.
No, margin is a separate matter. Margin is a matter for the bank to do.
No, it's a
So
support.
we are, the question is whether we accept net amount or.
No, that is right. But
Nowadays, it's a full amount.
but then the contract would be, then it would be a contract without any repayment obligation.
See, the contract is a separate, now like as Sir was mentioning, the holding company, the subsidiary which has to do a certain performance. The performance company and the other, where we be supplying the services, that contract is separate. But in order.
No, I'm saying the bank guarantee contract. The bank guarantee contract.
It's a basic contract.
No, basic or no, there is a repayment obligation, right? Company has to pay the bank back.
No, the company has an FDR already.
No, the FDR is separate. But there is first, every company is not going to default, right? Normal circumstances.
In case.
No,
but the question is whether to reduce that margin or not is what the question is.
That's exactly what.
All guarantee amount should be admitted.
Yes.
So,
amount should be.
But what will happen to the FDR?
Ma'am, if the FD amount is realized, the bank can't file the claim at all. No. Why? Then you sue the bank. If a bank is trying to get a claim also admitted and cash margin also used.
In that case, it's a better situation.
It's good that banks are
Yes. But that's the whole point of cash margin. That is the whole point of cash margin. No, the whole point of cash.
It's not that easy also.
I took a bit of what to do. CIRP expense.
उसमें ज्यादा कोई सबका डिफरेंट यूज है देखो बैंक से कैसे निकालना हुआ ना चाहिए
See, banks will not.
If they have filed the claim, you take back the money.
मेल करते करते थक जाओगे आंसर नहीं करते.
No, they are not required to give the money back.
No, but if they submit the claim of 100 rupees, if they submit a claim of 100 rupees and 20 rupees already.
Not required, sir. Let me say, there's a continuing guarantee. The corporate debtor is a going concern. I have filed my claim. Cash margin also is lying. My guarantee obligation remains. If the counterparty invokes the guarantee, I have to pay. Resolution applicant comes in and in the resolution plan, he says, I will roll over these guarantees and continue them. Nothing happens. Business continues as usual. I also don't get paid because guarantee is not invoked. But claim filing is me putting in my right to receive money. You can't say I don't even have a right to file a claim. There are so many cases, power companies, cement companies, which are working companies where guarantees are uninvoked at the time of CIRP, remain uninvoked throughout CIRP, and get renewed when resolution applicant takes over. So that can also happen. So we are looking at an extreme situation. Of course, no bank can get money twice. You can't say I usurp the margin and also file claim. That can't happen. In fact, there is a form which was introduced some 2 years ago that if any FC makes a recovery during CIRP, they have to inform you now. So if they don't inform you, you take them to court. If something like that has happened, and it's very unlikely something like that would happen. Whether the cash margin is
Extending that term, even in case of a term, let's say I've given you a 100 crore loan, which is secured by an 80 crore mortgage by a third party, you don't say 100 crore minus 80 crore and you admit 20 crores, right?
Yeah.
Like you admit this is exactly. Just because it's secured by some cash margin doesn't mean you
ultimately they've not got the money.
So at the time of recovery, they will reduce.
Yes,
Right.
yes.
Another question. What the RP has to do with the time barring debts? Whether he has to see whether the debt is time barring or not.
We have, but no, you'll have to admit the claim. In fact, there are some NCLT judgments on this. See, I mean, there are multiple views on this. Today, there is no Supreme Court position on this. The NCLAT's view in one judgment is that effectively that, see, time barred debt in the law of limitation, if your debt is time barred, does not mean the debt is extinguished. The debt is still there, but you don't have a right to sue for that debt. Only the right to sue goes away. Filing a claim is not suing somebody. It is only putting in your existence of your debt. So NCLAT says even if it is beyond limitation, you must admit it.
No, that's not time bound.
नहीं, बैलेंस शीट में साइन करते हो तो renew हो जाता है, वो अलग बात है. Let us say वो बैलेंस शीट में भी नहीं है. बैलेंस शीट में आज के दिन में नहीं है, but पहले था, बैलेंस शीट प्रिपेयर ही नहीं हुआ है. Some situation like that. But NCLAT has recently, when is this case, Ashwin? This is our case.
No, this is 2025.
No, this is a very recent judgment.
So one judgment,
Achha, it's your case only. Okay, okay.
One can tell more.
Yeah, I'm talking about that.
Achha, you're talking about this one.
Where is an incline?
Yeah, all right.
After the plan, everything, now NCLT has rejected the claim.
Sir, but this would amount to actually
Reject on the ground
giving a
it is
new
time
life.
On the law of
No,
limitation.
it's not.
How?
If the
Sir,
claim is admitted.
It's like saying,
Initially admitted, the case, the Supreme Court said this is time bound, so Supreme Court has turned it back.
Now again,
Then again admitted, and then you admitted that claim.
again, some party, other party, the CRP. Original party claim I admitted because claims on the same logic that claim stands. And I had taken a legal opinion on that. Claim stands, only the right to sue is gone, lost. But now, some on application, that claim is itself rejected. Now that party will go to the NCLAT again, so that battle starts.
Basically, like, there
But
are.
then laughing matter,
Huh?
yeah.
laughing matter.
No, this was, no, in this particular case, you're saying, again, the plan, everything is approved, but this logic, this is the same logic which
So
Ashwin is
you
saying.
don't get a new right. Effectively, it is like saying that just because a claim is beyond 3 years, does it mean your obligation to pay that money goes away? It doesn't go away.
There is a liability, but you cannot take actions to.
I can't take action,
But NCLT says.
but liability remains.
The NCLT says other way, no?
You can't change accounting laws because of limitation.
So debt remains and therefore it has to be admitted.
Because filing a claim is not suing someone. Limitation is only for causes of action of first instance. Like you will have limitation to file a suit. that limitation is not condonable. If you don't file a suit in 3 years, it's gone. That's first action. You can't take condonation of delay for that. There is no concept of condonation of delay for limitation.
In one of our case, the applicant has filed a claim. 1,550 days later, is a financial creditor. And the argument is going on there for
Yes.
time by days. Now he's initiating this thing because the RP we have rejected because it was a delay claim. And
Yeah.
also it came after resolution plan has already gone for voting.
That's a different matter. I mean, you don't have to admit it.
मेरे केस में तो शिवसेना प्लान अप्रूव करने के बाद में claim was admitted with 929 days delay, Central Warehousing Corporation. And the amount was freeze in terms
So,
of.
sir, I think we are talking two different things. You are
Yeah.
talking about time delay as in beyond that 90 days. You're talking about, that's not limitation.
That is not limitation, that is of limitation act.
That is not limitation. Limitation is liability का 3 साल तक कोई action नहीं लिया.
No, I think that one is delay in filing claim, which is beyond 90 days. Or now,
The RP, what we replied to you is that this is first of all, a time barring date.
no, I'm trying to understand what the facts are.
Basically, the
But
claimant
time barring
went
date
to
is- you are-
getting his claim admitted. The claimant went to NCLT for getting his claim.
No, but what is the delay in filing there? I'm asking that. What do you mean by time bar?
Time bar is, basically, it has already, they have not taken any action up to 1,000, but more than about 7 years old.
Okay.
There was nothing.
It's talking about
That's
limitation.
limitation.
What the issue?
So the other issue is so very fairly simple. NCLT always condones delay.
Yes.
But that's to be considered.
Yes.
Yeah, we can.
But I mean, that is only.
Basically, what that has said is that limitation bars your remedy, not your right.
Yeah.
Which means that now what that has gone on to say is that a claim is a right to payment. It's not a remedy to get payment. Because of that, while your right to file a Section 7 application is disbarred, if somebody else files a Section 7 application, you have the right to file a claim. And there has been actually been a very interesting evolution of jurisprudence on this. In some old case, basically like in 2017 or 18, there was a Section 7 application filed against a time party. Actually, the application was rejected. Somebody else filed a Section 7 application, he was admitted. The original applicant who had filed a Section 7 application, she filed a claim which was admitted by the RP. The disciplinary committee of IBC said that when NCLT itself said it's time barred, why did you use your brain and say that this should be admitted?
Same thing happening.
Yeah, but then thereafter, after this disciplinary committee order is in 2017. Thereafter, NCLT and NCLAT have dealt with this issue and they've said that what is barred is only your remedy and not your right. So therefore, claim admission is possible.
I think for us to understand, DC को साइड में रखो, वो दिमाग के बाहर की बात है, क्या सोचता है, क्या लगता है,
कौन सा?
may not disciplinary committee. What IBC says, what NCLT says, what Supreme Court says is what is relevant. DC वो तो उसको जो प्रैक्टिस करेगा एक नोटिस आने, लव लेटर आना ही है, कोई बच जाएगा, किसी को लग जाएगा.
With caution you can do, but some DC orders come on a particular topic. I think more cautious can be, IP can be more cautious. They can find some application.
Now let me dive to the.
Ultimately, you have to face them if they come. And those are important.
Rights of degree. In one of the cases, the degree holder has already, because he was holding the degree by virtue of selling the land to me. I am also, as a CD, I am a builder and developer. I purchased the land from him. I have agreed with some say 100 crore rupees value. Now 50 crore I have already given. The deed of conveyance and everything has been happened in my case. Conveyance deed has been already executed. And there is some legal dispute in respect of that land. So we stopped the payment of 50% balance. Now he is holding a now degree right because the company went into financial crisis and so on. So now he is claiming that he is basically a financial creditor because he holds the degree. The execution of degree was done by him, but it is pending with the court. It is not done, completed. The execution order is not come. So now he is claiming that he is a financial creditor, and he has the security of primary security of that land. You cannot sell that land as a your expression of interest. It is not your property.
Almost all real estate.
As per the order of consent.
he can be a secured creditor. We cannot be a secured financial creditor.
Yeah, right.
Why we decree? What
So
is the
whether
term?
you have decree or
Because,
not,
security arises, see, there are certain cases where security has been registered by either by some ROC, this thing, something, it has to be appeared in ROC or somewhere, or in balance sheet and everything. But here it doesn't. Yes, sir, you were saying something.
so whether you have decree or not does not matter. Decree is only a court adjudication of your right. As to what is your right has to come from the contract. So contract has to be looked at to see whether it's financial debt or not. Decree is only your claim form. In one more section, you will say, yes, I've also got a decree. So if you have got a decree, then obviously as RP, that sort of closes the matter. You cannot go beyond, you can't say, I disagree with the decree.
That is okay.
Yeah, so but,
Degree, I have admitted the amount.
but to in which category to put it, that will not be answered by whether the,
In fact, they have filed as a Form F, other claim, because in that degree, certain amount of right to be payable, 65 crore, plus certain land to be given to them, after developing certain area to be given to them and everything was there. So they have claimed everything under that particular.
And whether the liability is also linked to time value of money or not. So
It was linked in the consent form. Liability was linked in the consent, which was been given subsequent to the, I think, before CRP. It was only a consent form which was executed.
No, so he's asking that basically it's a, whether it's a financial liability or not, we could determine whether it's called time value of money or not. Whether interest component. How will definition में वो cover हो जाए?
No, it was not like that. They said, since this is the unpaid amount, say, XYZ amount, and it has to be paid along with the interest of 12% per annum. And this much amount of land is to be, this area to be given to them after construction, this demarcation to be done by them. So many things were there.
but your obligation was to give them land, right? Your obligation was to give them land or constructed area.
Yeah.
So your primary.
With all the type of rights, like monetary rights, as well as some physical.
But ultimately, unless something devolves in payment terms, typically it's not a financial debt obligation. It has to end in payment terms. If it ends in some service, some profit sharing, giving of land, then it will not be financial debt. So that will be the broad. I mean, in real estate transactions, sometimes the lines are a bit
Part of
blurred.
it was financial, part of it was non-financial.
No, even if it is financial.
The base is operational.
Yes.
So it's operational grade.
Even if it has to be.
It is not a loan. The example of the
Time
chartered
value of
accountant,
money
I
is
say,
not there,
I say
time
chartered
value.
accountant as operational grade because it was a service provided by him.
Yes.
Against which he got a flat, so he cannot be a home buyer.
एकदम common
Same
practice.
rate.
Creditor obtaining decree and filing a claim.
So why he cannot be home buyer?
Chartered accountant can got a flat against his outstanding from the builder.
But then once he got a flat,
And the nomenclature of flat, he has not paid for the flat and become a home buyer. He has got that flat against his service.
So there is actually law on this point as well. NCLAT says you can't barter. NCLAT says, especially in home buyer context, a lot of cases happen where operational debt, to keep the operational debtor satisfied, they are given flat. But they don't become financial creditors or home buyers. That's because NCLAT has taken a view that barter of claims is not recognized under IBC. Your original claim is that of a financial creditor.
but once converted in the claim is that of OC, sir.
OC, absolutely, OC.
In that case, if the claim has been already, honored by the CD management earlier and executed the registered agreement, in that case, you have to accept it.
Sir, but courts are not accepting it because the definition of a home buyer for the purpose of IBC is an allottee from whom money has been raised for the purpose of construction of the project.
Because in our case, even in every real estate case, there are a barter system which is going on. Again, the supply of cement, you are allotting some space.
But that,
Again, the supply
then
of,
it is operational.
material. Again, the supply of, labor contractor, everybody has been given by way of flats.
But
the base contract is of a vendor.
Agreement is registered,
Yes,
by the Earthware management before CRPD.
right.
Sir, we have a case where we are fighting it out, where home buyer segment is OC has granted. Matter, operational creditor who had number of flats through it, he controls the COC home buyers because more than 51% is he.
I see.
So whatever.
Class of creditor, only one person is there.
And then the dispute is raised and it is in the courtroom at this point of time where we, as a RP, we have taken our hand out. We said that you decide according to us, he is not a umpire. But you, the bench decides. We have put it across to bench.
decide.
Executed document or
Everything proper, nothing,
registration.
but he has got this in place for his construction work.
On the basis of.
And 50% more, so जो भी वो umpire का है, वो करेगा वो. Actual umpires are thrown out of it, so.
Now, in case there's a recall of the admission application, is there a duration assigned if in case somebody says their natural rights or whatever, that they have been affected?
Sorry, I didn't follow your question.
Normally, you have a duration for, recalling all these applications, like.
Recalling as in?
Recalling is suppose like there's a section 95 application which hasn't admitted.
Right.
Now.
You want to appeal against it?
They don't want to appeal, they want to recall the admission application.
Okay.
Is there a timeline?
See, recall itself is something, I mean, NCLTs don't have power of recalling all orders. If they are, say, procedural orders, NCLTs have power of recall. If NCLT has passed an order saying, I will allow you to file this document, but I'll impose 1 lakh cost, NCLT can recall that order. But once an order has been set in motion, which is a conclusive final order, NCLT cannot recall it. There are cases where NCLT has done it and NCLAT has said they should not have done it also.
Natural justice, sorry. Is there a duration?
No, there's no duration as such. The option you need to exercise is to take it in appeal. Because once, see, if it is only order of appointment of RP also, even then that order is challengeable. That order is challengeable. An order appointing a resolution professional under section 96 is also appealable before NCLAT.
It's appealable but not recallable.
See, there the line is a bit discretionary. NCLTs have recalled section 96 RP appointment orders, but the criteria for recall is very high. You will have to show the judge that you have on the face of it committed something wrong. Some gross error has taken place. You never should have passed it. Prima facie, judges do not recall orders because no judge wants to accept that she has made such a big mistake. So recall and review are very sparingly used provisions which succeed. Or recall can be like the example I gave. You have in that moment said 5 lakhs cost. The person comes back and says, look, I can pay 2 lakhs. This is the reasons, please reduce the cost. So that can be filed as a recall. So they'll say, I'll recall my order and reduce the cost to 2 lakhs. That's allowed because those are matters purely within the discretion of the court.
There's no time bar or nothing like natural justice that goes for something like.
No, you will have to do it. There's no, because recall is not even a stat. See, time will only be given if you have a statutory remedy. IBC says you can appeal before MCLAT. So IBC says you have to file appeal within 30 days. IBC doesn't say you can recall order before NCLT. There will be no timeline. Yes, but naturally, if you go after 3 months by which RP has prepared the report, then you cannot recall the order. RP has already prepared the report. That's nobody will entertain your application. That is not even a route that is available to you in the first place.
Because I've seen some applications like this and they've got no duration because normally anybody looking for an appeal would approach a tribunal between 30 to 45 days.
Yes.
As per the rule.
Though, I mean, I would be very surprised if those applications succeed. So recall is not something.
Thing that, Madam, next point, discuss.
So I think we can cover maybe a couple of points. One is, I think all of
I think we at least for half an hour or 15, 20 minutes, we see the presentation. What are the points?
Yes.
We'll not interrupt now.
Now we'll not interrupt.
So now
Only last 2 questions.
this can be taken offline. This can be taken offline.
Physical meeting is for the discussion.
I don't know.
Yes, but we had from 3:15, 3:20 to 5:30, almost 2 hours.
Okay, please.
No, I think just a.
It's quite interesting, so that I just wanted to check.
No, you also want to hear.
But anyhow, I think you have prepared a lot, so let us.
No, I think many of the points we have covered, but few points. I mean, there are a few points, but in the interest of time, maybe a couple of things. One is on, say, the distinction between certain kinds of claims where they are not actually creditors or for the purpose of haircut or extinguishment, EPFO and all sorts of statutory dues. I think all of you are aware of the change in procedure. At least EPFO has an elaborate claim form mechanism now. They have their own form. It's third-party assets in the hands of the creditors. That said, RP still has a role of verification. You still have to verify the EPFO's claim. It is your job to ensure that the claim is verified properly, but it is not included in the list of creditors because ultimately this is third-party assets. So they will be paid in full. They have to be treated and shown separately as EPFO dues, which goes for several other labor welfare sort of dues.
They pass very exorbitant claims nowadays.
Yeah.
They form part of?
Exorbitant claims they file.
Exorbitant claims. Where the company is closed also, they file.
So that is the point.
And
Best judgment and gives.
Yeah.
Huh?
That's the reason we need
Best
to verify.
judgment. Means
No, so if they have, so there are.
person रहेगा, उसके हिसाब से फिर भी
And they call so strictly, summons and everything, and
Yeah, they do.
as if they have a right to do anything, they.
How do we?
No, so if there is a final order passed and you believe it is correct, you should go in appeal. RP should file an appeal before the appellate adjudicating authority and under the Provident Fund Act. Like how you would challenge an income tax adjudication. You will take it in appeal. You cannot go to NCLT with everything.
So during this order passed during CRP, is it to be considered or not?
So that's another point. Now, the view is that during CIRP, you cannot do it. You cannot do assessment. The law is now that during CIRP, you cannot do assessment. During liquidation, you can do assessment. So, which is also a bit, I believe this law will change. It will keep changing because that is not the ratio of that judgment. The judgment was not on whether when you can do assessment or not, but it's a Supreme Court judgment. So today it's binding on everyone. So typically during CIRP, that's why you see people don't get EPFO notices. Because you can always reply and say there is a moratorium, you cannot do assessment. You can confidently take that position. There's a Supreme Court judgment on that point. But they are all waiting for liquidation order. As soon as liquidation order is passed, every day you will be summoned. Like we are doing some matters where there are a lot of hearings. EPFO will call you with short notice. And mostly there's nothing that happens in those hearings because there's no data, even they don't have data. But ultimately that exercise has to be done. But I think in EPFO, at least they will do it in two stages. One is that whatever they believe is the amount that you have not deposited, that they will be clear on, they will file. There also there is there's the two views, I think. One is incorrect in my view. There is a view that the penalty and the interest is not third-party asset and that is operational debt. Only the amount under 7B, which is the amount that you have deducted from the employee and not deposited, only that is third-party asset. But there is
Their asset. Sorry.
that's the employee's asset, which is third party. So, but there is a Supreme Court judgment, not very recent, quite old, which is accepted by NCLAT also, which says that is not the case because that interest and that penalty is also payable to the employee only because that also accrues to the employee's account because you have delayed in paying the money into the employee's EPFO account. So that interest you have to pay. And there is a penalty which is payable actually to the department, not into that account, but still it is third-party asset. That's what the Supreme Court has taken a view. And NCLAT in the context of claim verification has taken this view. Although NCLT Mumbai, in fact, in one of the cases that we were doing also, NCLT Mumbai has said, no, for this component you file a claim. For this you can file your own whatever document there is. Actually not correct, but that's so these are on statutory claims.
CRP, if you get a claim of assessment done during CRP, you can take a stand of and not accept.
Yes.
And what happens is it's an erstwhile promoter who has been taking a big chunk of money relative to the rest of the employees. And his PF dues are much higher than the rest of the employees. Is there any other provision for him, like the promoter director working for the company? Whose PF dues could be to all employees. Is there a provision where you're like?
But who is filing this PF due? The PF authority has claimed.
Because obviously calculations were done by the RP, presented to the PF authorities. PF authorities will add 7Q, 7
No, but in that if you believe the calculation is incorrect, that of course it is your job to submit the right.
Calculation is correct, obviously, because.
Only thing with the pain point is that money is going to the promoter. Money is going.
Getting a pay, but at least it's on record that he was getting so.
But how do you go back? How do you go behind that? As an RP, how can you take a judgment?
So then FC will collect through personal guarantee.
So you still have it.
Unless FC will collect through personal guarantee.
Yeah. Unless
EF money cannot be attached.
I'll still go ahead.
Department can still seek details.
Yes.
And they will say that we are not passing an order, you are saying moratorium.
Sir, but that also you can take a view that it is part of assessment. Ultimately, see, there are two things. One is that they will seek information from you for simply filing that claim form. They might ask some questions. Claim form as in the form that they file, which is under the EPF. I'm forgetting the name of those rules. They have come out with rules for
I'm not on EPFO. I would say I am on GST, sir. Now they want to.
But under what provision are they asking you information? There must be a section. No? If that section is for assessment, then you will not give.
So basically, they want to do scrutiny of returns filed by you.
Of returns, yeah,
They can do, but they cannot pass an order.
That's what I'm saying.
No, but
Because
they actually cannot do assessment. They actually cannot do assessment. So you can take a view that they can't even ask information.
We can take a view.
You can take a view.
But they cannot ask for a deposit while I file an appeal. I'll get a waiver for because GST and income tax there is a requirement of 20% deposit.
But I'm not aware of the provision under which you can seek waiver.
But then do I have to pay? Because already I am in this.
But you'll have to pay. Unless there is a provision for you to seek exemption. There is no IBC exemption.
Why do I pay them? I have. Then there is a claim.
That's a call you can take, sir. I mean, that's a call you can
But
take.
how do you file an appeal also during this period of monopoly? Appeal.
आप file कर सकते
You can file it.
It's one way traffic. It's one way traffic.
But this assessment provision is extremely true for income tax department.
Yes.
penalty है तो आप file कर सकते हो. Penalty का deposit भी.
It's a Supreme Court judgment. We can give it to you. This
I think
is
Sundaresh, but.
Sundaresh Bhatt only.
Yeah, yeah.
Sundaresh Bhatt.
Sri versus
ABG shipyard.
Like ABG shipyard.
ABG.
ABG shipyard. I think another that was one of the points. I think we have covered related party and all of that in CIRP. There is a judgment of the Supreme Court in Phoenix, ARC, where it's basically in presente decision. You'll have to see, typically we see this when there is assignment of debt during CIRP. And sometimes pre-assignment, the claim was with a related party. Post-assignment, it's an unrelated party, and they file a claim. That person to be in the COC or not, according to the Supreme Court, unless you have evidence or some indication to suggest that the assignment was done to gain backdoor entry into COC, otherwise you must have.
Everybody will do like that.
That's true, but the law on related party is not a purposive law. Related party has to be interpreted literally, not purposively. People in IBC, there is a tendency to confuse 29A with related party. 29A is a purposive law. You have to look behind what meets the eye. But related party is a test. If you are 1% below or above, you can be or cannot be related party. You cannot say it's only 1%, so I'll put them as a related party. That's not the purpose of the law. So therefore, Supreme Court says you must interpret it literally. And if on the day of the assignment, if on the day of the claim verification, the person is not a related party, you cannot say the debt was held by a related party before. Then you will have to show that the whole assignment happened with a mala fide intent.
Assignment of debt has happened.
Yeah.
And there is a change in RP, how do we reclassify?
You reconstitute and file a report with NCLT. It happens in multiple times. There are cases where reconstitutions happen 7-8 times. Yes, it's a Supreme Court judgment.
What
Phoenix.
happens during the course of CRP if SRA terminates my LOI and they issue a revised LOI with the financial gator becoming a joint developer. Do that financial gator become related?
Sorry,
party?
revised LOI as in, how will you, as in under the contract you're saying, not SRA.
Slum rehabilitation.
Okay, okay. The SRA as a
Saying
not
successful resolution application.
Okay, slum authority. Right, right. Yeah,
So now they issue, they make a financial credit within the CIBC as a joint developer.
right.
Do that financial developer, financial credit become a related party.
There are some case law on this. See, I mean, there is one decision where L&T is involved. This is a case of, I think there is a Pune-based developer called Exerbia Developers. So L&T is involved there. This case is actually going on in NCA where they are contesting this sort of. So L&T Finance and L&T Realty were involved. L&T Finance has then assigned the debt to an ARC. L&T Realty is still the joint developer, and they are taking an argument that L&T Realty's claim is a related party claim. It's okay, it's an operational debt claim, it's not a financial debt claim, but they are saying L&T Realty is a related party of this. That is their
Sir, which
claim.
bench is this?
NCLT. Right? But sir, I mean, see, on the day of claim filing, you meet the test of related party, you will be related party. That is what the Supreme Court says. You will not look at.
But on the day of the CIRP,
It's not on the day of CIRP. It will be on the date of the claim filing. Day of CIRP doesn't matter.
So it will be.
The claim filing was 7 days.
It can be a related.
It can be.
Yeah.
Because basically the judgment of the Supreme Court says, don't look at the intention. You can't look at, oh, I am only a developer. How can I be classified as a related party? There are cases, I mean, just for a moment, the first resolution plan that was approved in India was a case called Synergies Dure. It happened in
Hyderabad.
So at that time, there was no RP council, COC council segregation. I did that case for the COC, and I was also the RP council. It was the first case where before the insolvency law came, Edelweiss knew that the law is going to be passed and they wanted advice. Company was in BIFR. We were advising Edelweiss when company was in BIFR. It came out and all of that. 3 days before, and we had all made this grand plan that we will have this much percentage, that percentage, ye aayega, wo aayega. 3 days before insolvency commencement order, there is a 600 crore related party debt, which was assigned to a company called Millennium Finance. And that company was set up 6 months ago and had got ARC license about 4 months ago. And that and one CA was appointed as RP. And one CS was appointed as an RP. And it was a very celebrated case. Complete tragedy of the process, I must say, because it was really promoter who was running everything. But that was a case where this is what happened. We had filed application after application saying this person is a related party. But if that case would have been decided today, we would have succeeded because the intention was to get backdoor entry. Because they came in, my percentage came down, and we could also show that Millennium Finance had some link to other transactions where the promoters had used them. So that also we had shown. But because it was such early day, nobody knew what to do. NCLT didn't even know whether they can hear all this. One day NCLT judge said, you'll have to go to civil court for this related party, unrelated party. So in that whole delay, plan also came. So besides the point, actually, the government told the creditors, I mean, this is not recorded. So government told the creditors that don't challenge this process because it was the first case. And they said it will give the whole law a bad name. And of course, the RP became a scapegoat in that process. So
Mamta Binani was the
license
RP.
was suspended.
Mamta Binani, I think Mamta Binani was the.
Mamta Binani was the
Mamta Binani. Huh?
License was suspended for 6 months.
Mamta Binani
Yes,
was.
special relief act was also there, no? Some, in their case only special relief act by some Maharashtra government.
No, that was innovative. That was innovative. This is in Hyderabad. This was a case in Hyderabad. Yeah. Yes. Yeah. So there also this it's a case where how this assignment can completely change everything. Like even we are also doing one matter which is in MCLAT now, where because of that assignment, whole composition through the assignment, the fraction of COC got 66.7%. If one of, and there were multiple assignments, they all assigned to each other and formed a club.
That is one big account at present, real estate, large account. there was a deadlock because the 66% was not
Yeah.
happening.
Yeah.
And now there is one small account where there was an assignment done, and that 2%
Yes.
change has happened.
Yeah.
Now it has crossed 60. That 2% who do now he is controlling everything because now he has that 2% to make it 66.
But it's not necessary that it's not allowed. Because RBI says, for example, RBI recommends that if an ARC is buying a loan, you should endeavor to buy 75%. That's a recommendation of RBI. Because the whole purpose of ARP acquiring is so that there is one voice and easy resolution can happen. Because if there are multiple people, everybody has 5, 6%, 10%, you will never have resolution. Everybody will have their own vested interest. So aggregation is not against the scheme of resolution. It is in fact for the scheme of resolution that you aggregate.
But what happens in case it is less than 75?
No, there's no problem. I'm just saying that they are recommending because 75 is in IBC, it is 66 after it was reduced. But in a lot of other processes, 75 is scheme, you need 75.
You see, na JM and other, they mostly try to acquire above 75,
Yeah,
80,
yeah.
90 also. They
Like even in 7 years,
Yeah,
what he was
7 is
mentioning,
would be.
we were advising some parties
Along
there.
industry
So,
also, they are some more than 90%.
सब जगह पे होगा।
Bharti division advised 90%.
Huh?
उसका तो मॉडल ही हुआ है।
Model ही वो है.
so that was one issue. The other issue quickly, if we can touch, was
Sir, gratuity fund is compulsory, whether created, fund created or not created.
it will be third party asset like PF. If the money is not been credited. See, but gratuity mein there are more layers of it because you don't have to set aside cash. If you have an income tax trust structure with an insurance policy, that is also permitted. But ultimately, if the gratuity officer makes a claim, because if there are people who have left, you have to pay the gratuity in full under resolution plan. So your job as RP is to compute the gratuity and tell them that, look, this is the gratuity payout that has not been met out of the cash flows of the company. That amount has to be discharged in full. There is no haircut on that. That's the
The
only.
gratuity claimed by the employee.
Yes, it will be part of the
If employee
claim.
has not claimed gratuity, there is no payment.
See, even if it is not claimed as RPs, what we see as good practice, and I mean, Rahul will also confirm that, you will give the full gratuity amount, whether claim form is there or not there. Then you don't want some employees ke saath, you don't want issues. Bidder will go out of the way to ensure it's cleared because gratuity can become a criminal liability also. They don't want to get into that department.
We have done actual valuation and.
Yes, absolutely.
See, there is a different actual valuation, and actual value of the gratuity. Now, usually what happens, like my present SRA is basically, after me saying that the actual valuation is much lesser before I could have taken, possession of my corporate data. And I have done actual calculation of gratuity while, presenting it before the tribunal. So how do we address this kind of situation? Because obviously actual
It's not
valuation-
relevant because ultimately law says if there is 100 rupees of unfunded gratuity, you have to pay entire 100 rupees.
It's not about sitting and explaining them as to what actual valuation is and what actual.
It's the actual liability. Is
Yeah.
the liability which the company would have for that particular employee.
See, actuarial valuation may not even apply because actuarial valuation is only to cushion the company against the
Yeah.
impact of excessive employees leaving at the same time. But here we are talking about insolvent company where we are talking about actual money that was required to be paid to somebody but not paid. That is what is to be discharged. Future is on the SRA's hand. SRA can come in because a lot of these, like for example, Reliance has a group-wide gratuity structure. They have a group-wide insurance policy and a trust. They have one trust which feeds into other trusts. So whenever they acquire a company, within a year they restructure and connect it to their group gratuity structure. So they can do a lot of things like that. That depends on company to company.
An actual valuation is just an estimate basis the churn in the last few years.
Correct. That's right.
That may not be, in line with what is the actual liability.
An investor.
No, because assumptions are there. No? See, there is assumption of post escalation, the salary escalation, there is assumption of how much attrition will be there. In the CRP case, 100% attrition is what we have to consider. Whereas he will do 5%, 10% attrition.
Someone asked me this kind of a question, forget.
So one?
This expert who will answer it.
So the other, to touch on a couple of points, maybe on liquidation side. Sorry, one point I think which we found is coming up is difference between what is CIRP cost and what is a claim, right? And also maybe not on claim verification, but again, something related which RPs have to deal with is every single claim that is raised on you post insolvency commencement date is everything CIRP cost. So the short answer is no, that's not how it is looked at, because ultimately definition of CIRP cost is expenses incurred for the purpose of keeping the corporate debtor a going concern. Most cases, this issue may not lead to a very large delta. It might be a very small delta, but there can be cases where company is, say, not operating, and there are a lot of bills coming in because it could be leasehold assets that you're using for the business, and there could be huge liability that is coming in. But those bills are coming in because there is some asset that you are paying lease rent on, but you're not using the asset for going concern company, for going concern purposes, and maybe asset is not returned because there is some litigation going on. In these cases, RPs have taken a view that this is not a going concern payment, so this is not CIRP cost. So then where does that go? Does that fall into then some other component of claim? Now, if company, let us say this is in this case, there is a successful resolution plan. Resolution plans will typically have a extinguishment language, which says all claims will be extinguished as up to plan approval date. Then this is also gone because this is not in the claim list, so nobody gets paid. This is also not in CIRP cost list, so it doesn't get paid in the front and it's extinguished. But suppose this company goes into liquidation, then it becomes a, even then, I mean, then it's on the liquidator or RP really, because what liquidator will then have to do is you'll have to maintain some consistency. If you have said this is not CIRP cost, you can't add it to CIRP cost in liquidation. Then effectively you're really taking a position that, look, nobody has to pay this money. We don't have to pay this money. We don't account for it because it is not in the claim. It can't be in CIRP cost because you've taken a view that it's not going concern payment. The claimant cannot add it to claim up to liquidation commencement date because during that period it was in CIRP. So whichever way that component is added, you will have to take, but there's not so much law on this yet. There's one Supreme Court judgment which approves this principle. That is in a different context. It's in the context of employees, where there was a strike and there was during the strike, after post-strike company went into insolvency. Employees who were during that strike period, once RP took over, RP revived operations. When RP revived operations, RP called all the employees back. And there were some employees who did not turn up to work, but they are still employees on the rolls. So RP, and that was a significant number in that case. So RP said, I'm not admitting the claim. And it went into insolvency. Plan also got approved and everything, but that claim component went up to Supreme Court. And Supreme Court approved the RP's view that these people were also set of the people who did a strike. Some people came back. So they I have accepted and taken. But because it is governed by employee laws, RP did not retrench anybody's employment. Everybody were on the rolls. But RP said, I am not going to pay their salary because they didn't actually come to work, despite me calling them to come to work. Supreme Court said that's correct judgment because they have not contributed to going concern status. So if you no work, no pay, but in the context of going concern. So there are, I mean,
a very similar situation in Seven Hills.
Yeah.
During COVID, now it being a hospital, and we're we're supposed to run the hospital because there's like lack of bed. Yeah. And as as RP, we are struggling to get doctors back. So what we did is like we sent out this letter that no work, no pay. If you don't come, you'll not be paid and will not be considered as any as a CRP cost. And so what the outcome was that whoever came, we accounted for, we have been paying. Who did not came, the clock for the CRP cost stopped for them. So we did not incur anything.
In this case, if it is a statutory liability, for example, in one of my case, there are about 400 acres and 200 acres here. So 600 acres land nearby Bombay, which is NLM. And there is a property tax which is more than 1 crore a year. Now, if I say, okay, by this statutory, this is after CRP, my obligation to keep the, these assets in the time. Otherwise, it will, as per the law, they will have to,
Attach it.
attach, but, since section 14 is there, they cannot keep it. But anyhow, so whether should we say that this liability is no more payable as a CRP cost?
How will you say it?
Property tax liability. It has to, collected.
That has
It
to
is
be.
CRP cost.
फायर के लिए उनको क्लेम फाइल करना
I
पड़ेगा
mean,
During CRP,
it's difficult to get a general rule, but like I just take that example of maybe leased assets, right? Let's say that some, no, this is a different case, but let's say that your business is operating through leasehold assets. Could be anything, like even warehousing business or whatever.
मेरा SEZ का same issue.
Yeah, so now, once it has gone into insolvency, typically the lessor will say contract terminated, give my asset back. That will always lead to some litigation because CD will say, no, I have to keep the asset. If I give the asset back, then what remains? There's no business only, then the whole business is on leasehold asset. So that litigation is going on. And let us say that there is, because of that litigation, the asset is not returned, or there is a court order saying don't return asset. But because of the litigation, you're also not able to utilize the asset for the business of the company. So there is a stay. I can't run the business also because of the stay. Then why should I pay rent? This is a view that RPs have taken. I mean, it is not tested yet because.
Is it mandatory for the RP to pay the rental during the CRP period?
That is if you're using it. Here I am not able to use it because the.
But then you are not returning also, no? Suppose if I am a lessor, you are not returning me and not paying.
That's right.
So both you are having the cake and.
No, but we have gone to court. I said, let me use it, I will pay you rent. You said, no, I will not let you use it. I don't want to let you use it. I have terminated the contract. Even if you're willing to pay rent, I want the asset back. I want to give it to somebody else. Because you are saying I terminated the contract before CIRP started. Okay. So I am saying that I will pay the rent. Let me use the asset. So court has passed an order saying status quo. Nobody does anything. I can't run my business. I am not generating money. Then why should I be saddled with the rent as CIRP cost? It is your doing. You went and objected in court. Had you
I'm losing, I'm not getting anything.
That's correct. But there are cases like this which happen because in court, how things play out is not very predictable. So court has passed an order saying, kuch mat karo, status quo, we will see what is to happen. And my position is that had you not objected, you would have also got money because I would have used the asset. I am an RP. I would have run the business. I would have paid your rent. But because you objected, now I also can't use, you also can't use it. And then you can't claim rent from me because that would be like, how is it contributing to my going concern status?
But in earlier case which I discussed, it is not at all contributing that land, particular land which I told you. It is basically the main business of the company is of infrastructure development.
But you still have land in your balance sheet, sir.
Land is there in balance sheet. It is given as a security. And as of the date, it is as a security. It is not used for the business purpose.
But it was not being used for business purpose even before CIRP. No?
Yeah, before CIRP.
So then that is not even part of the business plan. I mean,
it is not a part of.
So I would say that you may not be able to use that argument.
I think another 5 minutes or we conclude now, I think.
Yeah.
Anything which is.
Anything, any particular point or.
Sorry?
To share the slides.
Yeah, we can send the slides, no problem.
Because today some members have not been able to.
Sure. We can send the slides.
At least they can get the benefit of this.
Yeah, I think we touched upon most of the points.
Is जो pledge of third party shares,
Right.
their claim, they file a claim as a financial creditor. But we treat them as a secured creditor outside COC.
It will be outside COC.
Correct.
That's right. There's no lending.
Because that pledge is not a guarantee.
There's no lending.
Correct.
I mean, there's no debt.
Because all of them are having third party pledge of shares.
Yeah.
And they have filed a claim, they want them to be inducted in the COC. So we have.
They have not given the money to the company.
There's a case, right? Premier Limited.
Yes.
Studied the contract act.
But then they have a claim against the.
No,
They are payable to the extent of the value of the shares.
That's what it is really like. There is this is approved in that Anuj Jain matter also. Like how
Anuj Jain and one Phoenix ARC.
Phoenix ARC is there, but Anuj Jain actually refers to an older Gujarat High Court judgment.
6 cases are there because I have studied that before
Right.
admitting the claim.
So see, a mortgage is also a form of guarantee, loosely speaking. Mortgage is guarantee with recourse limited to property. But mortgage is not guarantee in a corporate guarantee sense. Because in a corporate guarantee, you have personally undertaken liability to pay. In a mortgage, you have said, okay, I guarantee your debt, but if the debt is not paid, you can take the property. You can't come after me.
But now we are finding as a guarantee creditor where there is no corporate guarantee and there is no.
So that has to be rejected. I think that is settled now. Supreme
China
Court has-
Development Bank, they say that it is
So in
considered.
the Doha Bank or
Yeah.
China Development Bank, basically what happened is that in that particular contract, while it was a deed of hypothecation in some stage, there was another clause called covenant to pay. Where in addition to creating a charge of security, there was a clause which said that I will personally undertake to pay the debt. When this matter was at NCLAT, what NCLAT said was that a guarantee obligation is a very serious obligation. A one clause in a contract cannot be read as a guarantee, and on that basis, it said that this is just a hypothecation in mortgage, it's not a guarantee, and therefore not a financial right. Thereafter, when it went to Supreme Court, among other things, said something very interesting. It said that these days contracts are drafted by sophisticated lawyers who know what they are going into. So therefore, if there is a clause wherein which says that I have taken a personal covenant to pay, that clause itself cannot be treated as a guarantee. And on that particular clause, the Doha Bank judgment in that case said that this mortgage can also be considered as a guarantee. But behold such clause in an ordinary sense, a hypothecation document, a pledge document, or a mortgage document cannot be considered.
Yes, these cases clearly say that the place is not a form of guarantee. They have distinguished section
But now
175 and
banks are
126.
considering the covenant to pay, even a simple covenant to pay as a financial guarantee. And they file as a-
They are trying that, but you will have to look at it because ultimately, I mean, if the covenant to pay is not personal liability, if it is only again attached to the security, the secured asset, then it's not a guarantee. Guarantee has to be an unconditional obligation to pay out of your proceeds, regardless of where the proceed is coming from. Here you are saying, I will pay, but I will pay using this property.
Payout
So if the property is enough to discharge, it is enough. If it's not enough, it's not enough.
I think we,
So that's not a guarantee. Then that's a mortgage.
I think we conclude now.
Yes, sir.
Sir, last bit.
Okay, sir.
I haven't taken no question. No question.
Personal guarantee. See, personal guarantee has been already, easy case has been already admitted and we already, 1994 has been already signed and it has been accepted by the court and we have been told to proceed ahead in the matter. Now we have received the claim in respect of, the entity has already given the money to the partnership coming with the corporate guarantor, PG, personal guarantor is a partner to the extent of 50%. So they said we have given money to this particular partnership firm. And since he is a partner, 50% partner, we should admit or at least 50%. Because partnership is not the legal entity per se. It is a liability, is unlimited of partners.
Right.
So that is one of the question. And even we have received the claim pertaining to the claim of in the where he is an HUF. Where he is a member of HUF, Karta of HUF, and having the subsidiary. So whether should we admit this kind of claim?
Partnership claim would be admissible. I mean, you can see the partnership deed once, but typically it will.
From unregistered.
So we go to one step two steps ahead of this one. Suppose there was a beneficiary trust in that case, and one was a district, and the other was non-district. Again, then what would have happened? Considering a one is HUF, one is partnership, one is district, non-district.
They have given guarantee.
They are given a guarantee and they are beneficiary in all the trusts. So whether this is the HUF asset, whether the HUF asset can be considered as a part of the whether partnership asset.
But see, if you're Karta of HUF, that is little because you're only a trustee at the end of the
To
day.
the extent of your share, no.
But then I'm
For example, there are 4 members. So if 1/4 share, at least they can say give me 1/4 member.
But HUF is generally considered as a separate entity.
Yes,
See,
it's an entity. It's not like a
There's a
partnership.
different entity being considered.
Correct. That's
The
right.
income of HUF is being treated separately.
It's a
So you
trust.
cannot,
It's like a trust. HUF is like
you
a
cannot-
trust.
Likewise, the partnership firm also has the different PAN number.
So that is what the PAN number maybe is not the defining feature. It is on liability. in HUF, you have a structure of like a karta is like the trustee. HUF is like a trust, and all your heirs are the beneficiaries of that trust. Doesn't matter, but point is that today, who in your case is the personal guarantor here? The karta is the personal guarantor, and the claimant has said that I have a claim against the HUF.
Yes.
So that I would think cannot be admitted. That I would say would not have, cannot be admitted. Because ultimately that is like.
The claimant was running some Ponzi scheme like that.
Right.
And he has issued the receipt in the name of HUF.
Then you should just say Ponzi and not
He
admit.
was basically, he was a, financial among his caste. So few of the cast member has been given that receipt of HUF. And then they came because,
But it's undevolved interest. I would say it's undevolved interest. I mean.
He was a famous financial ranger. He was gathering the money on behalf of the entire caste and putting it money into a safe, and he was running it since more than 25 years.
No, but what Rahul is also saying is that HUF's liability is dealt with by HUF. HUF can take borrowing also.
HUF is only a creation out of Income Tax Act. It is not
Right.
a separate entity or any legal.
That's
status.
right.
Income Tax Act
But-
says that this is.
But it gives the status of.
Legal parents accept income tax. There is nothing known as HUF.
That is created because of that, but it is
Income
in a
tax has
separate
created
entity.
that
It's a separate
artificial
entity.
body, which is known as HUF.
Yeah.
So.
But it's like-
partnership act में तो act ही है उसका.
No, but that's right. But it's like an AOP, for example.
It's AOP.
But AOP can take loans. AOP takes loans. There are cases where two companies have taken a loan as an AOP. CIRP is admissible against both the companies also. So it's like that. So I would say, but in a claim situation, I would not admit it. For partnership, I would admit that claim, subject to the partnership deed. And it would not matter whether it's registered or unregistered, because that is only right to enforce rights inter se partners. No. Yeah.
If I'm a partner and other partner wants to enforce me, if it is unregistered.
No, but
then
he's
they
saying
cannot.
not other partner. He's saying somebody has given some service to the partnership firm, and he is one of the partners of the firm. So that would be admissible, I would say.
Derivative product.
Admissible?
That claim has come to us.
I would say it's admissible.
So HUF, then you say no?
Yes.
Partnership on.
Yes.
And what about the trust?
Trust, I think, would be the extension of the principle of HUF. Ultimately, because trust, though, it will be even more remote, because HUF is still not a registered trust. It is like a concept of a trust. Ultimately, it functions like a trust, but it's not registered as a trust. It is only registered for taxation purposes.
Unfortunately, the thing has happened in such a way that he was a financer, in the sense that he was taking the money from the cash member. There are so many widows who have invested because the amount was being given as an effective interest rate. So many widows who have already invested their hard-earned money and life-earned money to that particular person who was giving good rate for more than 25 years. It is not like a day-in situation, one day or but on one day after 25 he became bankrupt because he invested money in real estate.
In case one planning would have been done, the HUF would have been a partner in this partnership.
Yes, sir.
So look, we conclude.
Yeah.
I request Rajan Bhai to propose a vote of thanks.
Thank you. It's my honor to propose a vote of thanks for our speakers for the day. Friends, any good law to stabilize would take something like 80 to 100 years.
80 to 100 years.
80 to 100 years, yes. That
Not
is
in
how,
our generation.
that is how a good law stabilizes. We are still only in the 9th year of IBC.
But worldwide
So
it
it's
is more
an
than 80.
infant law. And that is precisely why we meet and we discuss the very basics of IBC, which is verification of claim. And you would all agree, so many ideas have come up, so many complex situations have come up in this discussion. Our speakers for the day they could have taken up this lecture effortlessly, but we can see that they have really taken a lot of efforts in preparing for this lecture. They have explained the concept very beautifully in a very simple, lucid language. So I have noted this. I would like to read this. Okay.
So I was trying to understand this difference between verification and adjudication, and I insisted on an answer on this. So I have noted this. So coming from the document is verification. What ought to come from the document is adjudication. So this is the thin line of difference between verification and adjudication, and we thank you from the bottom of our heart for sharing your knowledge with us, sparing your time with us. Please carry out these thanks with a loud applause. सर एक सिचुएशन बोलना चाहता एक सिचुएशन बोलना चाहता एक मिनट में खत्म करूंगा. सो मैं इनका मैटर डिस्कस कर रहा था सर, इनका एक मैटर डिस्कस कर रहा था. वो ओसी का क्लेम एक्सेप्ट नहीं किया. सो एनक्लैट में बेसिकली दैट ओसी वाज अ कॉन्ट्रैक्टर हु हैड डन कॉन्ट्रैक्ट फॉर अ डेवलपर. एक बिल्डिंग बनाया था उसने, राइट. इन एनक्लैट वी रेज दिस पॉइंट दैट जो उसने स्ट्रेंथ रिपोर्ट दिया था सीमेंट का, दे वर ऑल बोगस, राइट. हमने वो हमने प्रूफ प्रोड्यूस किया. अच्छा, नॉट रिकॉर्डेड इसलिए नाम लेता हूँ. वो रिपोर्ट्स लिया था भारतीय विद्या भवन से, विच इज अ वेरी
कॉलेज,
वेरी वेरी रेप्यूटेड. सो एनक्लैट को बताया कि देखो ये ऐसा है, तो बोलता है पैसा देके ये रिपोर्ट किधर भी मिलता है. दिस वाज द